What's going on, everybody? Happy Sunday evening. Welcome in here to Let's Talk Live here on LTL Media Channel. I hope everybody had an amazing weekend. It was a beautiful weekend out. The last 2 days, the weather has been perfect here in Massachusetts. Low humidity, nice sunny temperatures, and can't complain. And with that, if you saw me earlier today, I was out at a standout in Taunton, Massachusetts, supporting the Free Karen Read movement. There was well over at least 100 people there today on the green in Taunton. It was a great time. We all had an amazing time out there. And if you didn't get to go out there, at least you can go back, watch some of my lives, and see kind of what went down. So it was a really great day. Let me share this photo if you all haven't seen this. This is a great photo. I'm going to pull this up real quick. I love this photo. Look at this. Everybody at the standout. That's a great photo. Nice to see everybody out there. I got to meet some new people out there today, which was great. And I had a really good time. And we stood out there from like 10 a.m. to 12. And then afterwards, we went to East Taunton and spent some time at the Star Drive-In. There was pizza over there, and all the 20% donations, but all the money that came in, I believe today from 11 to 9 p.m. is going to get kicked back. 20% of it's going to kick back to Karen Read. So really awesome. Let me just go to the chat. Welcome some people in before we keep going on. Peggy's here. She was the first one here. Look at that. Peggy's here. Heather's here from Great Britain checking in. She said she had the notifications turned on. Adam, Humpty Dumpty, D.A. Morrissey needs to go. I totally agree. Berlin, Germany checking in. Look at this. Love it. Lit for LTL in the room. Hello, how are you? Good evening to you, Annie. Let's see. CPU Mod 1 is here. Hello, how are you? Welcome in. And Queen Olive is here. It's good to see you as well. Let's see who else we have. Mary in the chat. Good evening. Good evening. Nice to see everybody here. It is a good crowd. Very good crowd out there today. I love it. I love it. I love it. Love it. Kim's in the room. Love the Taunton video. Awesome. Thank you for watching. I appreciate that. Appreciate that. Susan checking in from Houston. Love it. Love it. Love it. Love it. All right. So what we're going to do is I have a little bit of some things that I want to go through logistically for tomorrow and this upcoming week, just for everybody, if you're going to stand out tomorrow at the hearing. Let me just pull my notes up here. So, excuse me. So we had the Free Karen Read standout in Taunton today. It was great to meet some new faces and see some new people out there. And it was a lot of people. I said probably well over 100. Lots of great photos in the Justice group if you want to go over there and check them out. And I posted a few of them on my Facebook page. I didn't take too many photos, and I didn't get around to doing interviews today. And I was kind of disappointed I didn't do that. But it was nice to get out there and just stand with everybody and just meet new people, which was great. So then after that, we went over to the Star Drive-In. I want to thank Erica for her hospitality over there, giving us some free pizza to eat. And then all the donations that came in today, I believe from, like I said, from 11 to 9, 20% of that was kicked back to Karen Read's Defense Fund. What I'm going to do here tonight, like I customarily always do, is the 25% donations, 25% of any donation that comes in tonight to my channel, I want to kick that back to Karen Read. And like I said, I like to try to at least get $50 so we can post that up on Karen Read's Defense Fund page. So feel free, super chat. If you want to donate, that's perfectly fine. If not, you know that I contribute here a lot on the channel. So tomorrow, let's talk about the hearing tomorrow. So there's a court hearing, obviously, tomorrow for Karen Read at the Dedham Superior Court. And that is at 2 p.m. 2 p.m. tomorrow. Just a couple things. Make sure if you can get there early. I'm anticipating that there is going to be a lot of people there tomorrow, especially mainstream media. Give me 1 second. I'm just going to turn my air on. Especially mainstream media. So the parking is going to be tight. If you've been there before, there is a lot of parking in the Deeds building across the street from the courthouse. You can just park from there and walk up. Make sure to dress for the weather. It's going to be warm. It's probably going to be humid. It is summer. Make sure to bring water and hydrate. That's the most important thing to do when you're outside standing in the sun. And there are some trees around there for shade, so you'll be able to do that. Excuse me. Let's see. Want to talk about there is no buffer zone tomorrow, so you'll be able to go right up to the courthouse. But I will urge caution in this. I have a couple of 2 points that I want to urge caution in. If the police on the premise tell you that you cannot go into a specific area and you can't be at a specific place and you need to move back or move forward or left or right, please listen to the police in and around the courthouse. Do not snap back at them. You will get arrested. I'm sure you will get arrested. So don't engage in negativity with the police. They're obviously there to protect, and everybody can have their own thoughts on the police. But we just urge everybody out there, if you are standing with the Free Karen Read supporters, please respect the law enforcement out there. Many, many, many of them are great. They don't give anybody a problem. So I'll just leave it at that. Also, tomorrow, I'm going to let you know this. If you are going to come down to the courthouse, there's been a lot of talk across all of the groups, Facebook, Twitter, whatever it may be, Instagram, whatever it may be. There are going to be counter protesters most likely down there tomorrow. All I urge you and all I ask you is to do this. Do not engage. That's what they want. That's what they want. They want a video. They want a soundbite. Whatever they can get, any type of negativity, to post it up on whatever platform they want to use, YouTube, Twitter, whatever it may be, and make everybody in this movement look bad. Obviously, we have a great group of people that come down there, and I would say 99.9999% of the time, there are no issues. Don't engage with these people. Turn your back. Don't give them any time of day. So I'm going to tell you. Also, keep in mind, there's going to be a lot of mainstream media down there, and they are going to look for situations like this. And I can already tell you the headline that will drop for the evening news: Free Karen Read supporters start trouble. I'm going to tell you right now, that's what they're looking for, and that's what they're going to try to do. So please, don't engage with them. It's not worth it. It's not worth it. Don't give them the soundbite. Don't give them the video. Let's just move forward. If the media comes down and they want to interview with you, fine. But don't engage with any of the counter protesters. It's just not going to be productive. It's not going to be productive. We did it last time. They showed up for about an hour, literally ignored them, turned our backs on them, and they went away. So that's the best thing to do. All right. What we're going to do tonight is I want to, since the Looking Back series has been really popular, what I want to do is go back to Karen Read's final pretrial hearing, and that was on April 12th, 2024. And we will play through this. And the reason I've been doing this is I want to see, for the people that haven't seen all the pretrial hearings and they only watched the trial and they went, geez, they were really railroading her all in through this entire trial, because there's a lot of new people that just came in just around the time of the trial and haven't seen the pretrial hearings. I want you to watch this pretrial hearing today and watch the continued railroading of Karen Read, infringing on her rights and putting out this completely bogus case against her. So we will play through that today. And let me just bring up the video here and we'll stop playing through it. All right, let me just get this up on the big screen and let's go for it. Here we go.
128th Boston Marathon presented
by... A little bit of conversation for about 5 minutes. I'm just going to speed that up. All right. Welcome in, everybody. Good to see everybody tonight. Thank you for being here. Thank you. Excuse me. All right, let me speed this up.
And good morning, Elizabeth Little,
Here we
also
go.
on behalf of Ms. Reed. Good morning, Ms. Little.
Good morning, Your Honor.
I have a
David Yannetti
surprise
for Karen
tonight.
Reed.
Good
I
morning,
have a
Ms.
surprise
Giannetti. Good morning, Ms. Reed.
We'll wait.
All right, so to begin, and I have all the motions in limine. I'll talk about how exactly we'll go through them in a minute. But first, so in reviewing the motions in limine, I mean, clearly the defendant has an absolute right, a constitutional right, to present a third-party culprit defense, but counsel is well aware that that is not without limit, right, from the case law. Now, the defendant has stood here, defense counsel has stood in this court repeatedly, stood here and in other venues and in their pleadings, espousing various third-party culprit theories or scenarios. But now that it's time to actually try the case in the courtroom, I don't have a motion from the defense to admit third-party culprit testimony. So, and as you're well aware, I have to make findings before any mention of any third-party culprit evidence or even an opening goes before the jurors. In order to admit it, and given that I have no information at all, I mean, I don't know who the third-party culprit is, even after reading 4,500 pages of discovery. I don't know what motive a third-party culprit might have. I don't know how it's relevant. I don't know if it's remote or if it's current. I don't know if it's speculative.
Oh, please.
Or if it's relevant. I don't know if it will prejudice or confuse the jury. And if it's hearsay, I have a whole other series of factors I have to consider. So, Mr. Yannetti, are you pursuing a third-party culprit defense?
We are, Your Honor, and I'm prepared to address that. The Commonwealth has raised the issue, and I am prepared to address that today.
So you filed your motions first and you did not raise it. So if the Commonwealth had not raised it, you did not move to introduce it, correct? I have no motion from
No, I
from you
understand.
about it.
I understand, Your Honor. If you'd like something in writing for us, we can do that. I have a full argument prepared.
All right, so who is the third-party culprit?
We are under no obligation to name any specific third-party culprit.
How am I supposed, so you're prepared to argue all this?
I'm prepared to argue it, Judge.
All right, so we will get to that when we get to the Commonwealth's motion.
That's fine.
Now, the second
Already
thing
starting.
I want to address, because again,
The attitude is already starting.
very important at this point. The motion regarding the DNA, regarding excluding the DNA. Mr. Lally, why should I not allow that motion?
For a couple of reasons, Your Honor. Number one, what I can provide to the court by way of update is that most of the testing with regard to that item is complete. So first and foremost, the item is hair. That was confirmed by the Bodie testing prior to them conducting any sort of mitochondrial testing. The mitochondrial profile, the partial profile that was generated in regard to the hair sample is complete. The mitochondrial DNA profile in regard to Mr. O'Keefe's sample is complete. The preliminary analysis that I received by way of email from Bodie yesterday indicated that they were consistent with each other. I asked for some sort of preliminary report or something that I could share with counsel based on their lab's accreditation. That does not permit them to release anything by way of a report prior to it going through a full review process. My understanding is that not only that process, but the entire lab file should be produced by Tuesday. On top of that, what I would state as far as any sort of prejudice the defendant appears that they've suffered as a result of that. There is still zero reciprocal discovery that I've received in regard to anything from counsel. And then part of the delay, at least a portion of the delay in this specific testing, as the court is aware, as you've had a chance to review Bodhi Technologies
put my duck?
observance policy as far as outside experts, there was a significant delay in hearing from counsel and for the defendant in regard to whether or not they wish to have someone present prior.
How long a delay?
I believe it was at least several weeks, if not a month. I mean, we spoke about it in person in December, and I don't believe that
My order was in November.
correct. So when we received your order was in November. What took a little time on our part was to get the samples taken from the troopers in regard to the other testing, and in order to get all of those items shipped and transported from the MSPCL to Lorton, Virginia to Bodie,
When was that done?
late November.
Go ahead.
Then there was a evidence viewing, which both counsel attended. We spoke about it there. I think that was December 1st. And then waited a few weeks, never heard back, followed up on it, and eventually heard back with regard to them not wishing to have anybody present for that.
When was that?
I don't have a specific date offhand, but
I need you to find it.
I can.
All right. So I didn't know that the defendant decided not to have somebody there.
Right.
And that prolonged it. They weren't able to go forward, right?
Yes.
How long will it take you to find that information?
Shouldn't take too long. I would need to check my email.
All right, I'm going to take a 5-minute recess.
Oh boy.
Do not wish to have observation for testing of the hair sample of Bodie.
All right, so that was about a month after my order.
Correct.
All right. And the defendant's asking me to exclude this in part because of the late disclosure of the information.
Yes.
All right, I'll hear from the defense on this, and then I'll give you an opportunity to address it, Mr. Lally. All right.
Thank you, Your Honor. I'd first like to address the timeline that Mr. Lally has just explained to the court. First of all, we were not made aware that we were allowed to test based on Bodie's protocols and procedures until December 1st. We were given a letter saying it would cost $21,000 for our expert to sit in on that testing. We reviewed that letter. We told Mr. Lally that it was most likely we were not going to have someone independently watch the testing because of the price.
When was that?
December 1st.
When? December 1st?
On December 1st.
Okay.
We confirmed that in writing when he emailed us again on December 22nd. And I would note for the court that Bodie did not receive the hair from the Commonwealth until January 11th.
Okay.
So
Yeah.
there was no delay on our part.
Cocktails at sidebar. I like that.
As the court knows, to date, we have received no reports from the Commonwealth regarding Bodhi Technologies' analysis of the DNA. The Commonwealth has engaged in repeated and inexcusable delays regarding the testing of this particular item of evidence, which at this point is sanctionable. The hair has been in law enforcement custody for more than 2 years, Your Honor. On February 1st, 2022, Massachusetts State Police criminalist Maureen Hartnett purportedly recovered a hair from the bumper of Ms. Reed's vehicle. For a full year, the Commonwealth did nothing. Finally, on March 6, 2023, criminalist Maureen Hartnett got around for the first time.
Sorry, criminalist department? Was that what
1 year, a full year, they had to do the testing on this hair. 1 year. Now all of a sudden, we're going to go to trial. Oh, let's do some stuff with this hair.
you said?
Criminalist Maureen Hartnett
Okay, yes.
got around to conducting a visual inspection of that hair for the very first time.
1 year.
On March 6, 2023, she opined that it appeared to be human. However, subsequent discovery produced by the Commonwealth revealed that she had failed her proficiency test in that precise subject matter only 1 month prior. Then, on August 25th, 2023, the Commonwealth submitted that hair to the Massachusetts State Police lab for DNA testing, and it was forensically determined that no human DNA was detected. Almost 6
How is this case even going forward? How is this case even going forward? There's no human DNA in the hair, and they still went forward with this case.
months later, the Commonwealth made their third attempt to find evidence establishing that the hair was somehow probative in this case. It is now 4 days before trial, and we were told that we're going to receive this on the day trial is set to begin. Pursuant to Massachusetts Rule of Criminal Procedure 14C, subdivisions 1 and 2, the court has the discretion to exclude evidence based on the Commonwealth's failure to comply with its discovery obligations. There's no excuse for a 2-year delay. We immediately conferred with counsel when he notified us as to what the requirements were going to be if we decided to have an expert present for testing. We got back to him the day that he emailed us following up about that. And they didn't even bother sending the hair to the lab until weeks later. So I don't think it's fair to blame the defense for a 2-year delay in this regard. As the court may know from the notices of discovery, we've received an overwhelming amount of evidence. This week, last week, the week before that, we're on the eve of trial. It is not fair to throw at us yet another item of evidence that we have to retain an expert to assess. We have to review, we have to make tactical decisions. That's not a fair position to put the defense in. We've been asking for a
100%.
continuance. I think the only fair thing if the court is going to force us to go to trial is to exclude this evidence.
Okay, thank you very much.
Thank you, Your Honor.
Mr. Lally?
Okay, thank you very much. Okay, thank you very much. Let's hear from Adam Lally. Let's hear from Adam Lally. Ooh, go back up here.
Yes, Your Honor. Again, not faulting counsel for any sort of 2-year delay period, but there was a period of time, given sort of the close nature of when the Commonwealth is receiving this information, that a couple weeks or a few weeks in this case do matter. The other point I would make as far as, again, as far as the defendant being prejudiced, this isn't evidence that I anticipate introducing in the first day, the first week, or probably not even the first month of trial. So whatever time counsel needs in order to retain an expert, run that by an expert, run that by one of their experts they already have. I don't know that, whether or not they have any experts, because again, I don't have anything from them. So as far as ample time, I would submit that there's more than sufficient time once the report is received for counsel to make use of it in whichever way they deem appropriate. And for that reason, and I'm certainly not asking the court to continue the trial date, but for that reason, I would ask that the motion to exclude be denied, absent any prejudice to the defendant.
All right, so I'm going to take this under advisement.
Yeah, I'm sure you are going to take
I
it
may as well
under
tell you that the
advisement.
best way, I think, for us to proceed with the rest of these motions is because they were filed so late, which I understand they were filed, just to be clear, I know they were filed by the deadlines, but so close to trial, I don't have written oppositions really unless you both raised independently the same issue. So what I will do this morning is my intention is to hear from counsel, to hear at least from the other side if the motion itself is clear enough, but to hear from counsel. Then we'll take a break, and at 2:00 we'll come back, and anything I can decide, because I know you're preparing this weekend to go to trial on Tuesday, anything I can decide by this afternoon, I will. Anything that I cannot, I will let you know. And then we'll do housekeeping, which I consider.
Oh, Melissa, thank you so much. Melissa says, hey, Brian, just wanted to pop in on a live and say I love your channel and appreciate your dedication. I'm usually on replay crew, but I'm always watching. Thank you. I appreciate that. Thank you.
Including, that's certainly a very important part of the case, jury voir dire in that. So that will come at the end of, that will come this afternoon. So starting with the view.
Your Honor, I was just going to notify the court, to your discretion, there are a number of motions that will be unopposed. I don't know if
All right, so what I'm going to do with that is the Commonwealth filed a very helpful list of what their numbers. We have, of course, the paper number, the docketed number. So when I get to
I need some
we'll
glasses.
just go through those quickly.
Whoever the court wishes.
All right, I appreciate that. So you, well, I'm probably starting with one. You could have saved yourselves time in writing the motion regarding the view, because you both want a view. I will conduct a view. You need to talk because you have different locations.
Yeah, and we've, upon consideration, Your Honor, the Commonwealth has asked for a view of 34 Fairview Road. We would be satisfied with a view of.
So you don't need to go to the waterfall?
I think that we can just agree to go to that one location.
All right.
Thank you, Peggy. You're the best.
Figure out the view.
You're the
I'm
best.
going to take under advisement your request of the defendant coming with us. You know that there are all sorts of things I have to consider before deciding that. Okay. So that part is under advisement. Before the end of today, figure out exactly what you want to do with the view. Mr. Lally, your office will provide state police escort for that view?
Yes, Your Honor.
Okay. All right. Now, court officers, Chief Rose usually gets the bus. So, all right. So for that, so the defendant's motion, it's our paper 283. Defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. So I'll hear whoever's arguing that for the Commonwealth. the Aruba incident, if you will. I mean, I'm sorry, who's arguing for the defense? That's what I'll hear from.
I am, Your Honor.
Okay,
Thank you.
You say 282?
283.
282.
Oh, this is all backwards. Pauline did this for me. All right, thank you.
Thank you.
Thank you, Your Honor. The Commonwealth seeks to admit irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence against
I
Ms.
gotta say, Liz shines a lot in this hearing. She does an amazing job. And, you know, you get and see her kind of full on board here. I love this. I love that they led with Liz in this hearing.
Reed by admitting inflammatory evidence of an event that purportedly transpired in Aruba on December 31st, 2021. As the court knows, this type of propensity evidence is extraordinarily prejudicial and serves no purpose other than to assassinate Ms. Reed's character in the eyes of the jury. The Commonwealth has put forth no reliable evidence to suggest that the incident that occurred in Aruba on New Year's Eve has anything whatsoever to do with O'Keefe's death, or that this remote and isolated incident was even a point of contention in their relationship at the time in question. And we aren't left guessing, Your Honor. All of the witnesses who were present at the Waterfall Bar and Grill on January 29th, 2022, along with high-quality video surveillance footage from that night, established that Ms. Reed and Mr. O'Keefe were happy, they were in good spirits, they were getting along. There is no evidence to suggest that this incident had anything to do with the facts at issue in this case. The Commonwealth points to purported angry voicemails left on the decedent's voicemail to suggest that there was some sort of hostile relationship between Ms. Reed and Mr. O'Keefe that night. However, these voicemails were left after Ms. Reed dropped O'Keefe off at Brian Albert's residence and after he failed back.
As far as I know, it's Yanetti's going to be handling everything. I'm not as sure as the new lawyer is going to be there, quite possibly. But I do know it's going to be David Yannetti tomorrow. Jackson will not be there, and Liz Little will not be there tomorrow. So it's all Yannetti. I'm going to tell you right now. I mean, a lot of people asking me today, how long do you think it's going to be? How long do you think they're going to take? How long do you think that they're going to be in the courtroom? I would say 15 to 20 minutes max, maybe 30 minutes. I'm going to tell you right now, judge's not going to want to hear anything. They're just going to move forward and retry this case. And it's a shame. You're going to waste all those resources, all that time, all that money to go through and get another jury that's going to be up there. And they're going to either acquit Karen Reed this time or going to be in the same exact scenario that just happened on July 1st. They're never, ever, 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 as many errors they have to put in there, they're never, ever going to convict Karen Reed, ever. I mean, you think now that you're going to find an impartial jury in and around this area? Everybody in Massachusetts knows about this case now. It's been plastered all over all the newspapers. It's been talked about all on the new on the local news stations here. Now they're, announcing a Netflix series. You now put that thought into someone's head. You think they're going to forget that? You're never going to find an impartial jury here. Never, ever, ever, ever. They're just never going to be able to convict Karen Reed because she didn't do anything. She didn't do anything. So it's waste of time and resources. They're just trying to bury Karen. They want her to spend exuberant amounts of money to go through this process. They don't care. And they're just going to keep pushing this all the way. The feds need to step in now. Someone needs to do something here. Say, hey, no, not this time around. All right, let's keep playing.
To come back outside to meet her. There is no logical relationship between the prior bad acts evidence in this case that the Commonwealth seeks to admit and the crime charged here.
That's it. I mean, they know that they can't convict her. They're basically trying to bankrupt her now, and they're just going to keep banging it out there, banging it out there, banging it out there. I agree, Rogue. Levy needs to step in. Where are you? Where are you? Okay, let's keep going.
And therefore,
here.
this evidence must be excluded.
Okay, come on.
Yes, Your Honor. So this also relates to Commonwealth's motion to eliminate number 20.
Yes.
So in regard to that, Your Honor, this is highly relevant evidence as it pertains to motive and as it pertains to the nature of the relationship between Mr. O'Keefe and Ms. Reed.
Jackson's coming back.
Goes to
not gonna be here
motive, it
tomorrow.
goes to absence of accident, goes to motive, absence of mistake. And this is not as The defendant seems to continuously try to pose it as some sort of temporary or isolated incident. This isn't just the argument or the yelling of swears between the defendant and Ms. Sullivan in the lobby in Aruba. This then leads to an argument which both children indicate in their statements continued inside the room in front of them for about 20 minutes after it happened. This is also not a fleeting reference in the sense that the defendant continuously brings it up on her own. Specifically in text communications with Mr. Higgins when she's talking about the nature of their relationship. And it's not just the voicemails that the defendant leaves on Mr. O'Keefe's phone after the murder occurs in front of 34 Fairview. It's also text messages exchanged between the two of them in the days leading up to that, in which they discuss the nature of their relationship. You also have statements from the children which indicate that the victim had tried to break up with the defendant multiple times in front of them, asked her to leave the home, and she refused. You also have a text communication from Mr. O'Keefe to Ms. Reed in which he indicates that he thinks that their relationship is essentially.
What was the date of that one?
I believe that was the 28th. Then there's other text messages from the defendant to Mr. O'Keefe referring to their relationship between themselves and with children as toxic. These are further statements regarding infidelity, which continue on to the morning of, in which statements that she makes in the backseat of the vehicle with Ms. McCabe and Ms. Roberts as they're looking for Mr. O'Keefe just prior to locating his body on the front lawn of 34 Fairview. These are statements regarding her belief in Mr. O'Keefe's infidelity that she repeats again when she's having her recorded interview with Ms. Voss from Boston Magazine. These are not isolated statements. These are not just one time 4 weeks prior. It's not too remote in time, and it does show sort of the nature of the relationship and as it's evolving over the course of that month from the date of the incident in Aruba all the way through until the date that Mr. O'Keefe is killed. And furtherance of that, also, there are statements that the defendant makes to paramedics when she's being treated on scene that the last time that she saw Mr. O'Keefe, they got into a fight or an argument. And she's upset because that's the last time that they spoke was during the course of a fight or an argument in front of the house on Fairview Road. So it literally continues from the Aruba incident all the way through to the murder's occurrence. So for those reasons, the Commonwealth would submit that it is relevant as to motive, it is relevant as to absence of accident, and it is relevant as to absence of mistake. Thank you.
All right. What I will need is exactly what the Commonwealth intends to introduce. I think you've outlined it and I'm familiar with it.
Yeah,
if I admit it, it would certainly be accompanied by very strong curative instructions, which you know is my right. I've heard argument now. I'm going to think about this and maybe decide by this afternoon, but.
Thank you.
Okay. All right, so you were both in agreement on what's the defendant's motion to exclude irrelevant and prejudicial evidence regarding alleged harassment and or intimidation of a witness, and the Commonwealth's for different grounds and different scope, actually. Motion to exclude mention of Aiden Kearney, aka Turtle Boy, and his pending criminal charges for witness intimidation.
Turtle Boy!
So, though you both agree it's out, that doesn't necessarily mean that I agree with you that it should be out. I understand that the nature of the harassment, mindful of the grand jury minutes that I've read, that in response to some of the questions posed by those at the U.S. Attorney's Office, the answers explained away some conduct as a result of the extraordinary harassment witnesses were undergoing. So I'm not sure I agree with you. So go ahead and try and persuade me, but what I'm inclined to do is keep it out in the case in chief, but Commonwealth said you told your witnesses not to discuss it. So I'll hear the defendant.
I guess I would start, Your Honor, by saying that in order for evidence to come in, it has to be elicited by a party. It has to be offered by a party. You're being told that the Commonwealth does not intend to elicit this evidence and that the defense does not intend to elicit this evidence. So I guess the question that I would direct to the court is, do you intend to follow up with questions?
I'm not questioning the jury. It's clear that it may be a response, a natural response by a witness that neither one of you intended to get as a reason for something, that I'm not going to sanction the witness because I allowed the Commonwealth's motion.
Sure. So
Mr. Yannetti, yes. So it's clearly you try your case the way you want to try your case, and the Commonwealth decides how they want to do it. But I am not tying the hands of witnesses to natural responses to questions. So I'm taking this under advisement. If you open the door, it comes in.
Well, I completely understand
Unreal.
that, Your Honor. I will say that I think probably, I don't want to speak for Mr. Lally, but
So don't speak for Mr. Lally.
but
I'll hear from him in
I'll
a
speak
minute.
for myself then if the court will allow me, which is
Yeah, he's
that
pissed there, man. Wow, he's pissed there. Let's go back a little bit.
will allow me, which is that if
Go back.
If you open the door, it comes in.
well, I completely understand that, Your Honor. I will say that I think probably, I don't want to speak for Mr. Lally, but
So don't speak for Mr. Lally.
but
I'll hear from him in
I'll
a
speak for
minute.
myself then if the court will allow me, which is that if a
That's the reporter right there that I don't know if you can see my mouse right here to the right of me. That's the reporter right there that gave that loving interview to Paul O'Keefe. I remember seeing her down at the court a lot. That's her right there.
a witness opens the door to a further explanation of this,
Yes.
that could give rise to
Correct.
both sides
Forgot the name.
exploring that, which
That's
you know,
her.
I suppose we'll deal with that when it comes
Right.
to it.
The way the motion's written, it would be prohibited, and witnesses, I'm not tying the hands of witnesses to natural answers that are the result of questions asked by counsel.
Right, understood.
Unreal.
Okay, do you understand that, Mr. Lally?
Oh, absolutely, Your Honor. And that was not my intent. Is if a
How the
question-
motion reads, your motion reads, Mr. Lally.
I understand. But it was more of a notice that the Commonwealth doesn't seek to introduce any evidence of that. But at the same time, obviously, if the truthful and honest answer to a question that's posed of a witness references that, then I think it comes in.
All right. So I think we're all on the same page. Neither of you intends to introduce this in your cases, but if you open the door, or if it's a natural response from a witness, it comes in.
Unreal. She hates the defense. She hates the defense. She hates the defense. It's only going to get worse. I mean, when they're back there, it's just going to get worse.
All right. So Jim, is 289 defendant's motion
I mean,
eliminated?
you really
exclude
think that Karen Reed's getting a fair trial here?
plasma, serum plasma, the blood, the alcohol testing, or are my numbers all off?
That's 289.
Yeah. All right. And the Commonwealth has a paragraph or two responding in one of your other motions. So I will hear the defendant on the motion regarding the testing of the blood from the hospital for the alcohol levels.
Thank you, Your Honor. I'll be addressing this with the court's permission. This is number, just so we keep it clear in my head, I had named this number 17, dealing with the retrograde extrapolation.
Okay, we don't have it as 17 anywhere.
I thought that was the list that the helpful list that the Commonwealth.
Oh, okay.
Right.
Our number is 289.
Right. Okay. So
And the Commonwealth's one paragraph response is 17, but you filed the motion. So why don't we hear from you as the moving party?
thank you. So the Commonwealth wishes to have Ms. Reed's retrograde extrapolation records admitted over, naturally, a hearsay objection, because the Commonwealth, their position is that they are medical records. The Commonwealth misapprehends the definition, the base definition of what a medical record is. A medical record, as the court well knows, holds a very special place in the evidence code, and that's because it's not compiled in anticipation of litigation. And for that reason and that reason only, they're deemed non-testimonial and not subject to Crawford and the defendant's right to confront and cross-examine witnesses or the experts behind the reports. Medical records are different than what we have here. The extrapolation records we have here are not medical records that were generated for treatment or Ms. Reed's medical history. They're the opposite. Those records were generated specifically in anticipation of litigation and in association with this criminal investigation. Thus, they are rank hearsay. The Commonwealth claims that the records are not produced in anticipation of litigation, stating basically that during her hospitalization, law enforcement was at the, quote, beginning stages of their investigation. But what the Commonwealth fails to mention or address is that at approximately 6:30 a.m. on a dash cam video, an Officer Good, as a matter of fact, a Canton police officer, states to Detective Lank that he is going to, quote unquote, section her, which the court knows what that phrase means. He's going to place a hold on her medically. Thus, the clear intent of law enforcement hours before the blood draw was actually taken was to keep her under law enforcement's thumb as she was an immediate suspect. But there's a bigger issue, Your Honor, and that is that the parties lack the essential, both, and by the way, this goes to the Commonwealth as well, the Commonwealth, but more importantly, the defense, we all lack the essential information on how the blood was actually drawn and tested. Those standardized protocols that we all get used to in the average OUI case, drunk driving case, they don't exist here. The standardized protocols for reliable testing, they're tried and true, and every one of those protocols is missing or are missing, and that leaves the defense having to sort of guess at the validity of the underlying test and the validity of the underlying test is the foundation on which the extrapolation is made, which is the only thing the Commonwealth really cares about. They don't care about the underlying test. They care about extrapolating backward several hours. But this sort of goes along the theme of garbage in, garbage out. If the underlying test was not valid, or it can't be proven to be valid, then, of course, the extrapolation is also invalid. The question remaining is, was the testing done by gas chromatography? Was it enzymatic testing? We don't know, and we'll never find out. We don't have reports to suggest that, or exactly what the validity of those tests were. So the initial result is suspect, and by extension, the extrapolation is also suspect. It bears pointing out, Your Honor, and this is the only sort of granular detail I want to get into, the extrapolation, according to the Commonwealth's expert, is somewhere between 0.13 and 0.29
good right here.
blood alcohol concentration. That is a swing of more than 123%. In other words, the swing of the extrapolation is larger than any one of the numbers themselves, which means it simply cannot be reliable. It illustrates the invalidity of the underlying serum plasma test, and for those reasons, the defense objects to the admission of both the blood test, the underlying test, as well as the concomitant extrapolation.
Okay, thank you. Kamala?
Doesn't care. Get Lally in there again.
Your Honor, so what the Commonwealth would submit is this may have been a valid basis for a motion to suppress, but it was a motion to suppress that was never filed, and one that the defendant specifically waived. Mr. Yannetti waived all motions to suppress. As it pertains to Mr. Roberts from the Office of Alcohol Testing's testimony regarding the serum conversion and the retrograde extrapolation, the reason for the range is because it's math, and essentially taking into account a number of different variables. That is why the range is as it is. As it pertains to the specific item that would be introduced into evidence, meaning the defendant's medical records, that's what the Commonwealth is referring to as the records coming in. Mr. Roberts would come in and testify as to his own analysis, his mathematical calculations, and the results based on his training and experience, which the defendant has had for over 2 years, as Mr. Roberts testified at the grand jury to that exact set of scenarios. As it pertains to the testing itself, the Commonwealth, as indicated on its proposed final pretrial memorandum, has summoned in not only the doctor who ordered the testing, the registered nurse, the nurse practitioner, who would both have been involved in the taking of the sample from the defendant pursuant to her medical treatment and medical diagnoses, as well as the director of the lab at the Samaritan Medical Center, who would testify as to what kind of testing is done and the nature of that testing and everything else. As it pertains to those witnesses, if the defendant wishes to conduct some sort of voir dire prior to the testimony in front of the jury, I certainly have no objection to that. But any sort of voir dire of Mr. Roberts or exclusion of his testimony would be inappropriate based on the fact that the defendant has had more than ample notice as to what the parameters of that testimony would be. So as far as what would be coming in as an exhibit, it would be the medical records with that amount in it, and there would be testimony from essentially anyone and everyone involved in the ordering, taking, and analyzing of that particular sample, which then provides the basis for Mr. Roberts' testimony.
Okay. So I have like one small paragraph from the Commonwealth on this. I want a memo on this.
Sure.
All right. So I'll take this under advisement.
She takes all this stuff under advisement.
Yeah. There's 17. We still need to address some more.
Commonwealth under advisement. It does hurt my hand, Gail.
So that's all of the
Tires
defendant's
my
motions
wrist.
eliminated, correct, Ms. Giannetti?
Wait just a moment.
Mr. Jackson, it's all of them, isn't it?
We filed a motion for attorney-conducted panel voir dire.
Yeah, that's a joint motion, and that's what I already said we're going to talk about impanelment this
That's
afternoon.
being complete in answer to the court's question. That was one that was not addressed, but that's fine.
All right. Oh, the request just to have panel, your motion was a little bit confusing.
Right.
So you want panel voir dire?
Panel voir dire, correct.
I'm not going to do panel voir dire in this case. So we'll talk about the particulars of it later this afternoon. All right. So on the Commonwealth's list of motions, you said that there are some that you may agree with. What besides the view? Are there any of these numbers?
Yes, Your Honor. The defense does not object to the Commonwealth's motions in limine numbers 1 through 6. Number 8.
1 through 6.
Yes, number 8. Number 9. Number 11, we obviously joined in that request.
Yes.
Let's see. Number 14, we do not object to. Number 15, we have no objection in principle, but we do reserve the right to object to just individual exhibits as they come.
Yep.
Number 18, we have no objection. Number 19, we have no objection. Number 23, no objection. Number 26, no objection. I believe
That's
the court
the
did
one we
reject that.
addressed, yeah.
And number 32, we have no objection.
All right, thank you. All right, Mr. Lally, I will hear you on our paper 297, your number 7.
Here we go.
So, Your Honor, this is the Commonwealth's motion to preclude reference and redact the manner of death contained on the victim's death certificate. This is a routine motion the Commonwealth files in really respect to any case. Manner of death.
That's not persuasive, so go ahead.
No. And I'm just manner of death as elucidated in the motion is not something that is typically something that is permissible to be testified to from anybody to the jury, because that's sort of the question of liability ultimately that is left to their discretion as far as how they find the facts. But cause of death obviously is something that is a medical determination. Manner of death, as the court is well aware, is there are essentially 3 or 4 different selections, and they fall into different categories. They don't necessarily mean in the medical context what they might mean in the legal context. So for that just sort of simple differentiation of meaning between the two, manner of death is not something that the Commonwealth feels is appropriate for the court, for any witness to be testifying to as far as the jury is concerned, as that's a question for them ultimately to determine. For those reasons, the Commonwealth would ask that this motion be allowed.
All right, who's responding to this?
Thank you, Your Honor. The medical examiner who completed the death certificate in this case concluded that the manner of death was undetermined. The Commonwealth now seeks to have that portion of the death certificate redacted because it is quite clearly exculpatory. All of the cases cited by the Commonwealth deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death as a homicide, because it violates a defendant's right to due process and a fair trial under the 5th, 16th, and 14th Amendments to the United States Constitution.
I love it.
None of the cases cited by the Commonwealth stand for the proposition that a medical examiner's determination that the manner of death is undetermined should be redacted. In fact, the Commonwealth cites Commonwealth versus Ellis at 373 Mass 1, it's a 1977 case, for the proposition that excluding the word undetermined is the better and safer course. But that's a misstatement of the law, and I would urge the court to read the Supreme Judicial Court's opinion in that case. What it actually says is this, quote, "Nothing contained in the record of a death which has reference to the question of liability for causing death shall be admissible in evidence. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial. Notably missing from that list of words that the Supreme Judicial Court warned about is the word undetermined. That is what the Commonwealth seeks to have redacted here. The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred, and their own medical examiner has opined that she was unable to make that determination. That finding is relevant, it's exculpatory, and there's no authority that supports its redaction. Thank you.
All right, Mr. Lally, the medical examiner will be on your witness list, right? I haven't seen either of yours witness list.
Yes, Your Honor.
Okay, so I'll take this under advisement. All right, Mr. Lally, your number 10, our number 300.
Yes, Your Honor. In this motion, the Commonwealth is simply seeking to obtain core information or records of potential jurors. I'm not looking for information pertaining to jurors that as they come in, or some voluminous amounts of every possible potential juror, but only seated jurors. And essentially, what the Commonwealth is requesting is to simply have some sort of verification that the answers that are provided by the jurors are true and accurate. This is something that is permitted by the case law, it's permitted by the statute, and it's obviously something that the Commonwealth would share with the defense as required to. But the timing of it, of what I'm asking for, and the limited scope that I'm asking for in relation to just seated jurors, once we have a full sort of set of jurors, whether that be 12, 16, whatever the court chooses as far as the number, I'm assuming approximately 16 or so. But once those are seated, the Commonwealth is just asking for some time to run those queries and provide those to counsel, and then make any further objections for cause prior to the jury being sworn.
Okay, so I know you're not in agreement. Are you opposing this?
Yes, Your Honor. Your Honor, we object for several reasons. First, the jurors are given a questionnaire which specifically asks this question. They self-report. We rely on self-reporting from jurors with regard to all questions. The Commonwealth has cherry-picked this one question to verify whether or not they're telling the truth, without dealing with any of the other questions that the jurors are asked. This proceeding right now.
Oh, Wendy, thank you so much. Kicking it off. $50 on Venmo. I believe it was on Venmo. Thank you so much. $50 on Venmo. 25% of that will get kicked back to Karen. And hopefully we can at least get $50 for Karen tonight. That would be nice. But thank you so much. Thank you, thank you, thank you. All right, let's keep continuing.
Like many
here.
of these
Thank you.
proceedings, is being broadcast widely, publicly. There are potential jurors out now listening to this, I'm sure, waiting for an answer from the court as to whether or not they will undergo that further invasion of privacy. And they are also, I would submit, aware that in this unusual case, the Commonwealth, through their special prosecutor, has sought to charge
Thank you, Jack.
picketers, protesters in a very unusual manner. We would claim a harassing manner. And our position is that this is just another method of harassment. We believe it's unfair. We ask the court to deny this motion.
Do you have any case law to support your argument, Mr. Yannetti?
Your Honor, the case law is simply the constitutional rights to privacy that the jurors have. I mean,
Yeah.
it's an issue of fairness, Judge. So that's what we're relying on.
All right. So the motion is allowed, Mr. Clerk, number 300.
Thank you.
All right. Mr. Lally, you're coming into number 12 with me quite skeptical. Number 12, leading questions for 13 and 16-year-olds.
And again, Your Honor, let me just first start by saying I don't think that this is something that's going to be absolutely necessary, given what I know of the two child witnesses in this case. Only filing under abundance of caution, more so should the need arise based on less so the age of the child, but the age of the child taken in conjunction or in the context of sort of the atmosphere of testifying specifically in this case, in this courtroom, with different things going on as far as the amount of people and things of that nature. So again, I don't foresee this being an issue, but just an issue that I wanted to flag for the court. Should it become an issue, and seek sort of the court's ruling or permission in regard to it prior to any sort of incident arising.
Okay, given that caveat, is there any objection?
No objection at this point, Your Honor. We can address it as it arises.
Okay. Mr. Lally, keep in mind the jurors would much rather hear from the witnesses than from the Commonwealth.
Of course.
All right. Mr. Clerk, on that, we're just going to withhold ruling. Withhold ruling until a later time. Commonwealth, you'll raise this again if need be.
Yes, sir.
All right.
DW, thank you so much for the $25 on Cash App. Thank you. 15%, I mean 25% of that
All right.
get back to Karen tonight.
So on your next
We're at
motion, you're
75
number
total.
13.
And for Karen is $19 right now. I'd like to get to 50. That'd be great.
I had
Thank
it.
you.
I don't have it in order. Just give me a minute. So I'm curious, do you happen to have, oh, we don't have the screen up. Do you happen, I'd like to see exactly what it is that you intend to introduce. So this is your motion eliminated to admit evidence that the defendant was in custody for a period of time after her arrest. Jim, is it possible for you to print that for me?
13.
Yes, please. Thank you. Okay. All right. I'll hear you on this, Mr. Lally, and remind me the date that this body cam footage was taken.
So, Your Honor, this is in reference to the defendant's arrest post-indictment by the grand jury in this case. It was June 9th, 2022.
So that's why I have not seen
Thank you, DW. I
the
appreciate
video
that.
itself.
Thank you.
Correct. And that's certainly something that the Commonwealth can provide for the court. But essentially, when she's arrested and during the booking process at the Milton State Police Barracks, the troopers who conducted that arrest were wearing a body-worn camera pursuant to their BWC policy with the state police. Counsel has a copy of the policy, counsel has a copy of the video, and essentially there are a number of different statements which provide sort of third, fourth, fifth, sixth, I'm not sure what number we're up to at this point, of sort of varying accounts that the defendant has provided to
Can you
numerous
give
people.
me an idea now? Do you know the substance?
So the substance of these particular statements is the defendant, Ms. Reed, continuously is told by Sergeant Buchanan.
Oh, this is that when she was sitting in there and she said, I'm now been arrested. They killed John, and are we all in the same? We all in the same movie together, or something to that sort. That's what he's going to talk about here. And he keeps telling her, oh, you should be quiet. You should be quiet.
To essentially stop talking. He's advised her over Miranda and advised her to stop making statements, and repeatedly states that to her during the
How
course
about
of her making
no?
statements. But the sum and substance of it is she says something to the effect of, are you in on the joke? And then makes some sort of reference to having witnessed Brian Albert and Colin Albert essentially smash John O'Keefe's head into the taillight, indicating that that's how a taillight is broken. Doesn't make any sort of further statements about.
That is a lie. She never said that, into the taillight. She didn't say that. She didn't say that. That's a lie. She didn't say into the taillight. She said they smashed his head.
Why she would then leave the scene after that occurred or anything like that. But these are, again, different accounts that have been made in direct variance to prior statements that she made January.
Michelle, thank you so much for the 25. She says, love the trip down memory lane. I get all worked up again. I know. And, and this is why I wanted to do these. So we'll add 25. This is why I want to do these, not to work everybody up. But like I said, there's a lot of people that came into this channel that just only started at the trial and haven't seen these pre-trial hearings. So it's always important to go back and see the process of how they continue to railroad Karen Read through all of these pretrial hearings. I'm going to tell you, it's going to happen again. They're going to have to go through all this again. It's unbelievable. They're going to have to go through this all again. I mean, I tell everybody, you think that she's going to walk in there tomorrow and Beb's going to go, oh, yeah, dismissed. It's not going to happen. They're going to push her and push her. And just like Rogue said earlier, they're going to keep pushing this to try to bankrupt Karen Read. And I talked about this. They need her. They need her for this. They need her to be the fall person because it covers everybody. If she goes down, the criminal investigation does not get turned on them. So they need her to go down for this. And they're going to push and push and push. And she's going to fight. And we're all going to continue to fight for her until her name is free and clear. All right, let's keep going.
29th, to the troopers, to paramedics, to treating medical professionals, to Ms. Roberts,
Margaret,
to Ms.
thank you for the $10 on Cash App.
To a whole other sort of slew and variety of people with a different sort of variation on what transpired each time. So it's sort of inextricably intertwined with the fact that she's in custody.
How so? Is she in handcuffs? Is she in a cell?
She's seated at the booking desk or the booking rail in the state police barracks. So I mean, I don't need to make direct reference to it. It's just, again, it's something out of an abundance of caution based on sort of where it is and when it is that the statements are made, that it may naturally sort of come out as far as if the court wishes. I think it's something that the court can cure by issuing a curative instruction if there's any prejudice to be suffered by the defendant. But again, it is a statement by the defendant, which is admissible, as the court is well aware. And then it is sort of in the confines or in the context of her being in custody when she makes that statement. I certainly wouldn't be trying to elicit testimony that she was in custody, but it is kind of apparent that she is.
Can you have that here for this afternoon?
Yes, I can arrange for that.
So you can see it?
Sure.
All right, what's the defendant's position here?
We object.
We object. Well done.
Your Honor, we're in a situation now where the Commonwealth arrested Ms. Read twice when they didn't have to. I made the argument to you at arraignment back in June of 2022 that after John O'Keefe was found dead on the lawn of Brian Albert's home, I immediately got a letter out to the state police saying, I represent her, I will surrender her, no need to arrest her, just call me and I'll bring her in. They ignored that and they arrested her to get her into custody. I would assert ultimately to make the arguments that Mr. Lally's making today. Then
we got it sped up a little bit, sped up just a little bit tonight. So that's why it sounds like everybody's talking a little faster, because it's a long hearing. It's 2 hours. We want to try to keep the show under like an hour and a half, 2 hours. So we sped it up, and I tend to stop and talk a little bit. I might interject and give some commentary over things. So that's why. All right, let's keep going here.
Astonishingly to me, after the grand jury issued indictments based on basically no new evidence, they upcharged her and once again did not contact me, despite the fact that she was completely in compliance with the terms of her release and had made every court appearance. They arrested her again. And so, again, I would assert to be in the position that they are in today. With regard to the case that they cited, Your Honor, Hoffer does not stand for the proposition
Oh, listen to
that they
this.
claim that it does.
Listen to this. I just got this from Double Good. Listen to this. Let me read this. What is this? Wait, hang on a second. I just got something from Double Good. I got to read this on air. This is, I don't know if this is real or not, but I got to read this. It says it's coming from Double Good. So let me see here. Let me pull this up. Okay, it's from an official account. Okay. Listen to this one. It says, my name is blank blank. I'm a user experience researcher at Double Good. We noticed you recently placed an order, and I and another member of the design team would love to hop on a quick video call and have you check out some of the new designs the team have been working on to provide your feedback. Yeah, I got your feedback right here. See that, Double Good? That's my feedback to you. Number one right there. Says it will take about it won't take any more than 20 minutes of your time. We swear. This is how it works. You select available time to talk Monday afternoon or Tuesday. We'll send you a Zoom link. Hop on the Zoom link on a device capable of Zoom screen, sharing the scheduled time, audio. I should do this and fucking record it and then call them out. I did. I put in refunds. I put in chargebacks. And then they're going to send me a $25 gift card direct to my email. It's not a sweepstakes. Scheduled time, join the Zoom. I got to do this. I'm going to do it. And I don't know if I can record it. I think that's illegal, but I'm going to tell them right there. That's what I think, Double Good. If you're fucking watching right there, that's what I think of your popcorn, because you shut down the Free Karen Reed fundraiser that we raised over $50,000 that your company would have got half of it, and you shut it down. So you know what? I want my fucking money back, $300, so I can donate that to Karen, straight to Karen myself. Pricks. Yeah, I should say, hey, I'm recording this. No, I'm going to send her the $300 that I gave the popcorn, but I want my money back first. So I should do this. I should do it after court, or maybe before court. I'm going to schedule a time later and try to do this. And I'm going to I'll just tell them I'm recording this. So that'll be great. All right, let's keep playing here.
In fact, the issue of that defendant being taken into custody was stricken by the court. The testimony in that case that was allowed or sanctioned by the SJC was evidence that the defendant had been living with his girlfriend but had unexplained absences. He didn't get along with her son. She was afraid of him, and that he associated with a convict that made her nervous. There was nothing about him being in custody that was admitted in that case. To the extent that these statements are, or the court deems these statements to be relevant and admissible, there are other ways to do it.
No, I believe that if you order, they're going to release it. They're going to release that order that you did. But I'm not going to support that company. I'm going to take my money and just give it direct to Karen, but I need to get my money back first. And then you will get your order. They're just not allowing us to do anything further on. They've nixed us from the website. So
do urge the court to watch
I'm not
the video.
supporting that
I could go
company.
put it on the screen because I want to see how the jury would look at it.
Okay, that's fine. But I will suggest, Your Honor, that there are other ways to accomplish that, either to have testimony about what it was, or failing that, to have the audio of my client making whatever statements they seek to introduce without the video. An image of my client, in handcuffs at a police station is what this court generally tries to avoid, given the fact that as she sits here and as this trial is ongoing,
a new member.
she's presumed to be innocent. We wouldn't bring her up here in an orange.
Sorry, I'm talking over the hearing. $5. I gotta remember I do that. Someone said, you talk over the video. You need to pause it. Okay, I'll pause it. Let's add $5 to the total tonight, and then we'll kick back 25%. Ollie kicking in 603. He says, free Karen Reed and Brian's hair. I don't have any hair. I don't care. I'm bald as fuck. I don't care. I always laugh about that. I always get a comment every there. Oh, he wears a hat because he's bald. I don't care. I am bald as fuck. I don't care. And I always said when I was born, I came out of the womb with a hat on. That's why I wear a hat. Just like it. It's a fashion piece for me. It's my personality. I love it. But thank you, buddy. Let's see. 603 says, in Brian's hair, oppressive hats, mind control headwear. It's not mind control headwear. It's not mind control headwear. Annie, 3-month member. Thank you. She says, thank you. I appreciate you being here. So thank you. Yeah, well. All right, well, let's keep playing on here.
And then ask the jury to make decisions about her. Nor should we display her.
It's controlling you now.
After a perp walk at the police station in handcuffs, making these statements.
All right, so I need the Commonwealth to. Do you have your media person available, Ms. Gilman or Ms. Crawford or whomever?
Don't make me pull my
duck. To make arrangements for that.
All right, we'll put it on the screen just so I can see how the jury would feel.
Holly,
all right.
Gifted 10 memberships. Welcome new members. You have members access, members only access. You go to my homepage, you can scroll all the way down and you'll get all to the members only content. So we'll add $50 to the total. Then 25% of the total tonight will get kicked back to Karen Reed. We're trying to at least get to $50. I think we're there. I think we're there right now with the 50 that just came through. I don't know. Rogue should have a total and we'll do the 25% off of that. That should give Karen at least $50 back. All right. Oh no, not the duck. I'll pull the duck out. I'll pull the duck out. I will pull the duck out. I will pull the duck out. Don't get me started. Let's see. Sharon, thank you. Unbelievable. At the same time, very believable. The Commonwealth would do this over and over again. Like I said, they want to bankrupt Karen Reed. That's all this is about. They know they can't convict her in the court of law. They know they're never going to find an impartial jury. They know that they're never going to find a jury that's ever going to convict Karen Reed because Karen Reed didn't do this. So it's always going to be a mistrial. And what they want to do now is continue to bankrupt her. It says the FBI told them the first time, don't do this. Absolutely. I love it. We'll add $10. We're at 180, 181 total. 181 total, 25% of that. I think we've reached, all right, we're at $45 goal. We're at $45. Need another $5 to get us to the $50, at least the $50 tonight to get that kickback. Absolutely. That's what we're going to continue to do. That's why when I do these shows and I take in any Cash App, Super Chats, Venmos, anything like that, I will kick that back to Karen Reed. I will give her 25% to help out. And we've raised well over 5,000 already on this channel. We've already kicked back 5,000 to the channel. We just had a PayPal come in. Julie, thank you so much for the 25. So we'll add $25. Yeah, I've already donated $5,000 back to Karen Reed's defense fund. All right, let's keep playing through.
Thank you. So we'll look at that this afternoon.
Ollie, thank you. Very kind.
I'll hear you on the celebrate motion, your motion number 16, Mr. Lally.
My ducky puppet, my Lally puppet.
Thank you, Your Honor. So in this motion, what the Commonwealth is requesting is for permission for the celebrate expert, Mr. Whiffen, to conduct a demonstration in the courtroom during the course of his testimony in regard to the examination that he did in regard to Ms. McCabe's extraction report and specifically the alleged search, which the defendant purports occurred at 2:27 in the morning and the Commonwealth maintains occurred at 6:23 and 6:24.
I'm going to stop you because one question is, how long will this take if we allow it? How long will the demonstration take?
How long?
So really what I'm seeking to do ideally would be for sort of a live demonstration, which I had Mr. Whiffen do and record and provided a copy of that to counsel as well. So that recording that I provided has no audio to it, but there was also a PowerPoint presentation that Mr. Whiffen prepared in relation to the same issue that he produced, and then I provided that to counsel as well, which essentially goes through what he did. And it also—
You're not looking to do a PowerPoint presentation, are you?
No. The PowerPoint presentation would not be something I'd be looking to admit. The reason I did the video is in the event that technology is not our friend on that particular day and the live demonstration doesn't work. I would then be seeking to introduce the video and have him talk about it while it's playing.
I'll tell you, I'll tell you a video that I did want to see. And if this goes to trial again and the ARCA guys come back, I want to see some type of demonstration. I think that was a miss with the jurors. If they had a reconstruction demonstration video, I think ARCA would have nailed it down and it was swayed all of those jurors. Because that was why I was waiting. The two ARCA guys sat down. I said, ha, ha, ha. I got my knife. I got my fork. I have my big steak in front of me. And I was getting ready to eat. And I'm waiting. And I'm waiting. And I'm waiting. And I'm like, all right, where's the reconstruction demo video? I mean, we went and looked on their YouTube. And they had these beautiful rendering videos of reconstruction. I'm waiting. And I'm going, all right. But it was just verbal. And I'm like, oh, no. You need to show these jurors. You need to show them. And they didn't do it. So I'm hoping that this time around, the defense leads with ARCA right out the gate, get it in the jury's heads when they present. If we go back to trial, they hit with ARCA right away. Hit with ARCA right away, and we need a video presentation. Video presentation, reconstruction. Kat Randall, thank you so much. Got to put up the tuft for the hair on the ducky. Yeah, I gotta do something. I gotta get like a little mohawk or something, some glasses. We'll fix it up and make it look like Lally. So when we're lollygagging over here. Yeah, I gotta get a better one. This one's kind of short. It falls off my hand. It's not long enough. I wish it was longer because every time I push, see, it just falls off. So we'll work on it. Thank you for the $10. We'll add that to the total. All right, let's keep playing through here.
It
Having a little
mirrors
fun tonight, right?
essentially or exactly what Mr. Whiffen had included in his report, which was done back in almost a year ago at this point, and has been provided to counsel. Is essentially the same thing as what's contained in his report, but just as far as a visual aid and demonstration.
Oh, you're right. Maybe she did.
I just think it's when particularly talking about sort of the technical aspects of his particular analysis, the Commonwealth would submit that it would be helpful and assistive to the jury in order for them to have that sort of visual demonstration to go along with obviously the oral testimony of the witness as well.
We need to do that.
All right. Who's arguing this for the defendant?
Michelle, thank you for the
we
$10
received from the
super
Commonwealth
sticker.
video
I
that
appreciate that.
Mr. Lally just described.
I like your little dinosaur
about 48
sitting
hours
in the
ago.
chair.
So we have not had an opportunity to confer with our expert about that.
I want to go back because Liz is arguing a good point here about their expert.
Assistive to the jury in order for them to have that sort of visual demonstration to go along with obviously the oral testimony of the witness as well.
All right. Who's arguing this for the defendant?
A lot of Liz in this. I like it.
Thank you, Your Honor. We received from the Commonwealth the video that Mr. Lally just described about 48 hours ago. So we have not had an opportunity to confer with our expert about that particular issue.
Okay.
Unreal.
However, just from sort of a cursory review, it does appear that its admission is improper. As the Commonwealth acknowledges in its motion, in order for the court to allow a courtroom experiment or reenactment, there are very strict rules concerning that experiment. It has to replicate with exactitude the actual event so that it is fair and informative for the jury. Otherwise, it's prejudicial and would serve only to confuse the jurors. Here, just based on a cursory review, it does not appear that Mr. Whiffen's in-court experiment replicates all of the factors that we know were in existence at the time in question.
Does it replicate the factors that he says he considered?
So I'll need to have a little additional time if the court doesn't mind to confer with my expert.
Yeah, so I will give you time to confer with your expert and file a written response. But that's one of the factors that I'm asking you to look into.
Understood. And then just if the court does intend after a written briefing to consider admitting that evidence, we would ask to be able to take their expert on voir dire as to that particular issue.
Okay.
Thank you.
All right. How much time, Ms. Little, do you think you'd need to confer with your expert and put something in writing?
I believe about a week should be sufficient, Your Honor.
Okay.
Thank you.
And I'm sorry, I neglected to answer the court's question as far as timing. The video demonstration, which is essentially what I'd be asking him to do, is about 19, 20 minutes.
Okay. All right. So, Mr. Clerk, that's under advisement. So what remains on Commonwealth's motion 17?
So I just put in the call for tomorrow at 5 p.m. with Double Good. I'm going to give it to him. I should have done it earlier. They had an open time slot at 3, but I didn't want to interrupt with anything down at the courthouse, and I should have gave it to him down. What I should have done was went down there and then have everybody behind me and tell them how much we hate Double Good now. That would have been hilarious. But I will be talking to them tomorrow at 5 p.m. So we'll see what happens. If I can try to record it or whatever, I will. But, you know, I'm going to be professional. It's not going to do anything if I get on the phone and go, F you and F this and that. I'll just tell them, you know, I'm really disappointed at what you did. And, you know, we raised a lot of money. And because of one troll email, you shut down the whole campaign and won't let us do that any further. You got to be professional. You know, listen, I know you get on here and go, screw them and blah, blah, blah. But look, you know, and if I'm not getting anywhere, maybe I tell them to go fuck off at the end of it. But we'll see what happens. We'll see what happens. I mean, you gotta approach it in a professional manner. Just let them know, look, I'm really pissed off. I'm displeased at what you did. We raised a lot of money. And then all of a sudden you shut down the campaign because one troll email. It's ridiculous. And we would have continued to use them, you know, used it in the past. Made a lot of money for that company. Used it in the past. I mean, that's an incredible feat to raise $50,000 in like 4 days. That's incredible. And they're going to get a huge percentage of it. But to shut us down and just say, hey, no more. That's it. And not hear anything or speak with someone from the movement. Fine. But I'll let them know. All right, let's keep playing through.
The statement. So I know this went to the blood draw, but there were statements. That's what separates this from the defense motion to exclude the testing. So I'll hear you on that. Is the defense objecting to that portion of the Commonwealth's motion?
Thank you for that opportunity. Not particularly, no. It's the blood draw and the extrapolation.
Yeah, so the motion had both. So that's why, all right. So I guess we don't need to hear. So the part of your motion that concerns the statements made by the defendent, the defense
Judy,
is not
thank you
objecting
so much
to.
for the $40
Very obviously, they're admissions. And
on
the rules are dealing with
PayPal.
admissions. So I'm not concerned about that.
Okay. All right, so Jim, on 307, it's a split. The Commonwealth is permitted to introduce
Thank you. That was very
statements.
nice. Appreciate that.
Made for purposes of medical treatment. And the certified medical records.
Right back.
But there's an objection as to what we've heard regarding the alcohol testing, the blood testing for alcohol. Okay. All right, your number 20, Mr. Lally. Our number
20, Your Honor, I believe, refers back to the same argument that the Commonwealth had made in opposition to the defendant's motion to exclude anything about the nature of the relationship,
okay.
Things of that.
That's why I don't have it right here. Okay. 21, the out-of-court statements regarding the victim's state of mind.
So 21 sort of pertains to that same issue as 20. So essentially, it's the same argument. You're on the same facts underlying it as far as statements that the victim, Mr. O'Keefe, made
But were you making statements regarding like bins in those cases, Commonwealth versus bins, the state of mind of the defendant, state of mind of the victim, the defendant knowing it, the defendant being able to act as a result specifically? Okay.
So on that sort of specific application of it, and that's why we filed two separate motions in relation to it. But as it applies to that, the Commonwealth would submit it as clearly met its burden under the case law as it applies to that because of the nature of some of those communications. So it's not just communications that are observed by other parties as far as what the victim, Mr. O'Keefe, indicated to Ms. Reed, or these aren't situations like in some of the case law where it's an indication to a third party and the defendant.
Kat, thank you so much for the one gifted. Yes, they do count. I just make them $5. $5. You do a gifted membership, it's $5. We'll add that to the total, and then we had $40 come in from PayPal. I don't know if that got added. So $45 added to the total.
And wasn't present, and then there's sort of an inference that can be made that, well, if they're saying it to this friend of theirs, then they must have communicated that to the person with whom they were in the relationship with. In this instance, Your Honor, we have direct communication between Mr. O'Keefe and Ms. Reed via text communications from each of their phones, indicating that communication about ending the relationship was made just prior to the date of his death in this particular case. So it not only enhances, but what I would submit is corroborates that testimony from other sources or from other family members and other witnesses. So for those reasons, the Commonwealth would ask that this motion be allowed.
All right. I'll take it under advisement.
Your Honor, on this motion, our
Don't worry,
position is that we'd like more
Don't
specificity
worry, don't worry, Mr. Lally. You're gonna get everything you want.
about which statements the Commonwealth is indicating they seek to admit. I imagine
It's the
that's
same thing I said to you, Mr. Lally, on the other one that was
right.
Don't worry,
in
you're gonna get
connection with
everything you
this.
want.
So the Commonwealth will do that.
Yes, Your Honor.
And I think then at that point we can evaluate it, Your Honor. Certainly some of these statements are going to come in, but we'd like the opportunity to be able to object if they.
No, I agree. So it has to be clear. So
We
you
got
know, as far as your notice to the defense, you can even point to.
see David Yannetti just walk away in like disgust. Let's back that up a little bit. Watch him walk away in disgust.
But we'd like the opportunity to be able to object if they.
No, I agree. So it has to be clear. So, you know, as far as your notice to the defense, you can even point to grand jury minutes or whatever, but I need to know the statements you intend to introduce.
Understood, Your Honor. And what I can do and what I aim to do is sort of an ancillary thing is I'd like to, if the court is amenable and counsel is amenable, to pre-mark as many exhibits as possible, just to make the situation easier
Don't
for
worry,
both
Mr.
sides,
Lally. You're
as
gonna
far as
get everything you
referencing
want.
documents, photographs, videos, things of that nature. So when it comes to, I'm not seeking to introduce, when it comes to any sort of the cell phone abstractions, I'm certainly not opposed
Excuse me.
to admitting the entire abstraction dump essentially from anybody's individual phone. But what I'd like to do as far as exhibits are concerned is to print out or create sort of extraction reports from those cell phones as far as different communications between person A, person B, just to make it more simple for the jury to digest it and more simple for, I think, everyone involved to understand sort of the exact communications that we intend to talk about. So in that vein as well, what I can do is provide a supplemental memorandum in regard to 20 and 21, referencing sort of those specific conversations.
Okay. That'd be great. And if you can work together, and this will be part of the
Don't
housekeeping.
worry,
we
Mr.
talked about
Lally.
this
You're gonna get
afternoon.
everything you want.
Work together to pre-mark exhibits. That would be great. All right, so 22.
So again, with respect to 22, and I think the same can probably be said for 23 and 24 and 25, is that essentially, as I've stated earlier, the Commonwealth is somewhat operating in the dark, and that I don't have any discovery, I don't have a witness list, I don't have any investigator reports or notes or notice of an expert or notice of any sort of expert reports, curriculum vitae, really anything. So out of an abundance of caution, the Commonwealth filed motion to eliminate number 22, which is in reference to any alleged bad character or any prior misconduct of the victim or any witness that the defendant alleges to seek to elicit through whatever witnesses they may or may not have. But essentially, what I would state in regard to this specific issue is that, as the court is well aware, it has to be something that is, first of all, relevant to anything, and it also has to be relevant to a reputation, and not just an anecdotal something that's brought up from one witness, again, who I don't even know who those witnesses would be at this time. So I don't know that the court can rule on it without any sort of notice as to whether or not the defendant intends to seek to introduce such evidence or has any such evidence or who those witnesses would be or what their level of knowledge would be. But it's something that I at least wanted to flag for the court in regard to if it comes up as we go along.
Who's responding?
That would be me, Your Honor. Thank you.
Okay.
This will be very brief. The Commonwealth, at least in their moving papers, Mr. Lally,
Oh,
I think
cool.
has gently stepped back from
I
the moving papers a
love
little
him.
bit.
He's awesome.
The moving paper suggests
That's cool. I'll have to go back and watch that. Yeah, I didn't get a chance to watch it because I was out there today. But him and I did a recorded live the other day. It was so good. And he just said he hadn't gotten around to editing it yet. He's gonna hopefully get it out. That's cool though. He's a good dude. Like, we have been texting the last couple of days too. And it was such an awesome, recorded live. I love the way he did it because I've never met him before. And, we just got on and started shooting the shit. And then like we were comfortable and he goes, I'm just going to start recording. And he just started recording and it was just like the best. It was the best live. And I was nervous because I've never done that before. I've always just watched the chat and kind of interact with the chat. And he's, it was cool. Like, we did like an hour and a half and he shut it down. And I thought it would be like, oh, hey, thanks. But like afterwards, we just kept talking for like 45 minutes. And then he's like, take my number. Let's stay in touch. Let's do more things. And I'm like, yeah, totally. Like, I got to get you over on my channel and like hang out. So super nice guy. We had super, super good energy. Like, It just worked really well. And I said, dude, anytime you want to do anything, I know we're 3 hours apart, but anytime you want to do anything, like, you're always welcome, like, on the show, and like, let's do more stuff. He's like, no, we're doing more stuff. Like, it was awesome. Good energy. I'm like, yeah, absolutely. So I like Collier Landry. Go check out his channel. Go check out his story if you haven't heard that yet. Super nice guy. Looking forward to do more things with you if you're watching Collier. And I can't wait for the show to come out. I'm really excited about that. So, all right, let's keep playing through. I appreciate everybody being here. We got about another 35 minutes or so. Like I said, we're doing this kind of replay to get everybody geared up for tomorrow. We'll go from there. We'll go from there. All right, let's keep playing. Alan Jackson arguing.
They seek to preclude the defense from presenting any evidence to the jury that one or more of their witnesses lied or gave false information in this case in any particular. They call this, they do this under the rubric of bad character, but that misunderstands or misapprehends what bad or what character evidence actually is. Character evidence or bad character evidence refers to using past behaviors or past traits of a person to prove a propensity to act in a certain way in the future. Conversely, proving that someone lied or gave false or misleading information in regards to a specific matter that's relevant and material to the case at hand, that's called impeachment.
Excuse me.
And that's allowed in every single courtroom across.
So impeachment's certainly allowed, but do you intend to put on witnesses regarding challenging character evidence?
No, we're not intending to. That's exactly what I was going to summarize by saying that the bad character focuses on general character traits, whereas impeachment deals with people who lied or were untruthful. We intend to do the latter.
Hold on, Mr. Lally, you're not objecting to impeachment, prior inconsistent statements, things like that.
No, of course
So
not.
Counsel, you mentioned that there is a distinction between character evidence and straight impeachment. Character evidence is not permissible because you're not going to introduce it, you said, right?
We're not seeking to introduce it at this point, and we wouldn't. I mean, obviously, the trial has to play out, and it's going to be several weeks. And by the way, Mr. Lally has mentioned over and over and over about how he has no reports and no statements, et cetera. He's got more than 7,000 reports and statements, both from his own investigation and from the federal investigation, that in no small part encapsulates a lot of what we intend to impeach with. However, as I stand here today, I can report to the court that we don't intend at this juncture to put on bad character evidence. We don't know what that might look like. But if we did, obviously, I know the rules. I would give the Commonwealth due notice and the court notice before we went that direction.
All right. So 312, Mr. Clerk, is allowed. If you need to readdress that, defense counsel, you need to file a motion. Okay. So 312, Jim, is allowed. Same thing. Do you intend to put on character evidence? It's a difficult standard or potentially problematic, but do you intend to do it?
Your Honor, we at this juncture do not have intend to put on character evidence, but we will give the court notice as well as Mr. Lally notice if we do change our mind.
All right. So 313, Jim, is allowed and defendants can renew it.
I'm sorry, what's the second part?
Defendants can renew it
Yeah.
by written motion.
7,000. Yeah. 7,000 reports.
How about 24?
Kelly Reed checking in. I love this. Kelly says, hey, everyone. Great seeing you today, Brian. I'm watching, but I'm not chatting as much as my eyes are messed. Yes, you were suffering from allergies today. Yeah. And she says, I love these pretrial hearings. Kelly, I don't know if you heard, maybe you did, my stance on double good, but they actually reached out to me and I have a Zoom call with them tomorrow at 5 p.m. So pending on what goes on in the courthouse, I'll definitely take the call. I actually texted Paul and just let him know. And I said, hey, if there's anything you want me to say to them, let me know. I'll handle it professionally. And tell them, like, look, it's ridiculous. That one troll email got shut down that whole campaign. And we raised a lot of, everybody, saying we, meaning everybody included, they all raised a lot of money for that company. What do they take? 50% of the profit from that's an exuberant amount of money. I'll approach it. I'll talk to them. I found it ironic. They reached out to me. They probably saw all the chargebacks because I did almost $300 of chargebacks. And I've been pretty vocal through all of this and I'm upset. So I'll hand it professionally. I'm going to try to record it. And she said, I have things to say. I'll chat tomorrow. Yes. Let me know. Single-handedly, $60,000. $60,000. I'm taking the call at 5 o'clock tomorrow. So if there's anything that you want me to say or need me to say, let me know. We'll chat tomorrow at the courthouse. And if we're down there in and around 5 o'clock, just depending on how things go, join the call with me. That'll be very interesting. And we can have some words. But anyway, we'll talk tomorrow about it. All right, let's keep playing through this.
Is there an objection to that?
I believe that was 24.
No, it's 23.
Maybe I can get them to
Oh,
change their
I apologize.
stance.
23, we had said we had no objection.
Okay.
You know, I'm going to talk to Paul tomorrow. I'm texting with Paul right now. Kelly will be there. I'm going to find out the total that we raised through through all that fundraising, through the popcorn, and just let them know. I mean, if it's like $100,000, say, look, we raised $100,000 through campaigning through your company. Why would you shut that down? So maybe we can get them to change their stance on it. So, okay, we'll keep playing here.
I didn't
And
have that.
Maybe
24
give me a
is
little bit
the
of an
winner
advocate
character.
here.
Okay, so 24s. All right.
I'm sorry.
24 is allowed, Jim. 23 and 24 are allowed. All right. There's an objection to 25, Ms. Little? Just
Yes,
yes or
Your
no?
Honor, Mr.
All right.
Jackson is-
So I'm going to hear from Mr. Lally on the motion. I just wanted to know if there was an objection.
Excuse me.
Your Honor, I could probably, if I don't mean to step on Mr. Lal's toes. If he wants to talk, he can talk. We don't anticipate asking any of our experts to read from the treatise. If that's what his concern is, and that's how I read the motion, we don't anticipate going there. That might short circuit this.
So no treatise, no studies?
They will refer to studies, not going to read from studies on the witness stand at this point, at this juncture. Certainly, their studies are the
Your
foundation.
sharing says they're going to follow through. But after that, there's no more. But maybe I can change their mind tomorrow. I know it was a little heated. I did the old, this is what I think about your company, but maybe I can approach this differently and approach it in a very professional way and just see what their stance is. And if they give me kickback, I'll just say, you know what, screw you. Thanks a lot. Have a nice day. So we'll see what happens. All right, let's keep playing through, my friends.
Of every expert's testimony.
Okay, but what he's saying is he has no discovery of even who your experts are. So how's he going to read all these
I
articles?
understand. I
So
understand that. As the court knows, and we anticipate, and I think Mr. Unetti is going to address this with the court soon enough. he will
That could
getting
be
our
it.
expert reports. We now
Easy.
have finally their
That's a good analysis. The chargebacks are probably burning them. That's why they want to talk to you into reversing them. Well, no, they said they wanted to talk to me. The email said, I'll read the first email again really quick. They're going to give me $25. I don't want $25. I want Karen Reed to be able to campaign through this. It says, we noticed that you recently placed an order. I had another member of the design team that would love to hop on quick video call and have you check out some of our new designs the team has been working on. Well, yeah, what design you should have? A bag that says free Karen Reed on it. That's the design that you should have.
their final notice of what
We'll
their
see what
discovery is.
happens.
certificate of compliance.
And we are anticipating by the beginning of trial, by Tuesday, to have something in response to that. But no, we're not going to elicit an expert to sit there and read from a study or read from a treatise, if that's what their concern is.
Anything you wanted to add to this? It looks a little broader than that to me.
It is a little bit broader than that, as far as it also refers to anecdotal experiences or things of that nature, which obviously wouldn't be contained within a study or wouldn't be contained within certain materials. So I'm sure counsel is well aware, and I'm not certainly saying that they're not, as far as what an expert can testify to and what an expert cannot testify to. But essentially what an expert can testify to is facts that they personally observe based on testing or things that they do themselves. Facts in regard to things that are in evidence or things that the counsel reasonably expects will be put into evidence. But the studies themselves, any sort of anecdotal experiences that they may have had or any sort of scientific literature is not something that is permissible to be admitted as an exhibit. So if that is something that they seek to talk about, the Commonwealth would submit that
Oh, we
that's
have a
improper.
fan in the
what they did
chat.
in this particular case,
A
sort of what their baseline
fan.
of experience is, what their baseline as far as
We have a fan in the chat. Oh. Is that a fan? Is this a fan? Are they saying that to me? Is that a fan? Oh, I have a fan.
their educational background in order to form some sort of opinion based on the facts as the jury finds them is certainly fine. But making any reference to because it happened in this study, it must be true in this case is something that's simply not permitted.
Okay,
If I may, just briefly,
sure.
Mr. Lally uses the phrase anecdotal experience. That's the first time I've ever heard that in this context. I don't know what he means by that. But if what he means by that is bringing into court something that the expert has done or experienced or has experience with, and then relating that
I think
back
so
to
too,
his
Mary.
opinion or her
Now that it kind
conclusion,
of clicked.
Isn't that what he's suggesting Mr. Whiffen do with his in-court experiment? It sounds like an anecdotal experience, but that's just me. I think we have to take this on a case-by-case basis and figure out what the experts are going to say. I don't know what anecdotal experience means. So I can't really defend against that because I've put hundreds, if not thousands of experts on the stand. I don't know that I've ever asked, can you tell the jury what your anecdotal experience is with fill in the blank? So I'm not sure what and I'm not being glib, I just don't know what that means. So I don't know that the court can adequately rule on it. I think this may be something that we wait until.
So let's get the list of the experts. Take a look at the Commonwealth's the defendant's expert discovery to you, and you can raise it again.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
So, Jim, let's say no action taken. All right, 27. I'll hear you, Mr. Lally.
Yes. So, Your Honor, this motion eliminates in reference to prohibiting reference to any federal investigations conducted by the U.S. Attorney's Office or the Federal Bureau of Investigations. So, to this point, the U.S. Attorney's Office has publicly confirmed that at no time has the U.S. Attorney's Office named any person or entity as a target. So, any sort of reference to and essentially what they've stated throughout the course of, and I know the court has had a chance to.
I want to slow this down because I want to pay deeper attention to this. So let's go to normal speed here. This is important. I want to go back what he just said. They have not pointed out anybody.
And essentially what they've stated throughout the course of, and I know the court has had a chance to review those materials, but what they state is essentially their investigation into some unnamed criminal activity or some unnamed crime or there's nothing specific to any specific person or entity that is contained within those materials. So what the Commonwealth is submitting is that any reference to the fact that those things occurred is therefore unfair, essentially biases against one side or the other based on that, and it really has no relevancy. As far as making reference to, if counsel at some point either side wants to make reference to testimony or statements, reports, things of that nature that were provided in the course of that discovery pursuant to the TUI, obviously that's perfectly permissible, but it also can be done without making reference to where that item came from. As far as you testified previously in relation to some investigation on such and such a date, you spoke to a law enforcement agent on such and such a date, and you said this. So if it's needed for those kinds of reasons, as far as impeachment and whatever, that's obviously perfectly permissible, but any reference to that in front of the jury, Your Honor, is something that the Commonwealth would submit is simply impermissible and irrelevant to the facts as they pertain to this case. So for those reasons, the Commonwealth would ask that this motion be allowed.
Is there an objection to this?
There is. Your Honor, the Commonwealth's position can be basically summed up in their moving papers with the following sentence that they drafted. The proceeding would be unfairly prejudiced if the defendant is permitted.
Kelly, are you? Oh my God. I guess I can. Hang on a second. I'm texting Kelly Reed right now. Let me just add these up. I'm going to add something up. I'll just let everybody know. Let me see. Let's get her permission. I mean, I guess it can. So let's just do that. 11,400 plus. Hang on. I'm just adding something up. Let's see what she says. I mean, it was transparent anyway. So hang on a second. Okay. So Kelly Reed sent me. All right. So one of the campaigns, I'm just looking at the double good popcorn. So one of the campaigns was 11,396. Oh, by the way, I got glasses. They're coming. I went and did the big boy thing. I held out for as long as I could, but I have some glasses coming, some readers, so I don't have to squint anymore. Let's see, 19,108. This one was 30,691. Holy crap. I was right, about $100,000. 599. $114,794. And that was the four that, and Kelly said, these are the four fundraiser totals that I had participated in, but there was one more that I did not sell during the trial. $115,000. And Double Good doesn't want anything to do with this. How much? There's one more, she said. Kelly, how much percentage does Double Good take from that? Is it 25 or 50%? So at 115,000, let's just say it's 25%. They're going to get almost $29,000. $28,750 if it's 25. It's 50 fucking percent? You got to be kidding me. So we essentially raised $57,500 for Double Good, and they're going to say, we don't want anything to do with you anymore? Oh, I got something to say to them at 5 o'clock tomorrow. Holy shnikes. Yeah, I got something to say to them tomorrow. But we'll do it in a respectful way. Maybe I can rattle some cages here. You know, what do they say? The squeaky wheel gets the grease. So we'll see what happens. And then if they don't want to work with me, I'll just tell them to go take a flying F. You know what I mean? All right, let's keep going.
To rely on the mere appearance or existence of a federal investigation, especially where the investigation was shaped and influenced by the defense. First of all, the defense does not and did not shape or influence any federal investigation. The federal government is more than capable, Your Honor, and I think the Commonwealth knows this, of making its own decisions and about its own investigations. Second, and just as importantly, the Commonwealth cites no authority whatsoever that stands for the proposition that the mere mention of a federal investigation prejudices state court proceedings in any way, shape, form, or fashion. And that's because there is no authority. That authority does not exist. But most importantly, and this is critical, it is going to be critical to give the trier of fact, this jury, the proper context in which every one of the statements or every bit of the evidence is presented and how it came to light. It's essential for the jury.
How are you going to do that? How do you propose? Is somebody from the U.S. Attorney's Office on your witness list to come in and talk about it?
There are federal agents. No. We don't anticipate presenting the fact that there's a federal investigation.
Isn't that what this does? If you mention it,
no. What this does?
Explain to me why that's not so.
That's what I'm doing.
Not yet. You haven't. So please explain that.
As the court knows, it's essential that the jury is given the context in which every single statement, whatever the statement might be, is brought to light.
Does that mean? Do we say in the prior trial that resulted in a mistrial, you said this?
No, but you would say when you were speaking with Officer Smith or Officer Jones from the Canton Police Department at the Canton Police Station in this particular context, did you say this? When you were questioned by the Commonwealth's attorney in this proceeding, did you say this? When you were questioned by the United States attorney in this hearing, did you say that? That's what we do. Otherwise, it's perpetrating a fraud in the jury. The information that's gleaned during the federal investigation was revealed, Your Honor, importantly, by a neutral third party, a neutral body that's not connected in any way to this case. The Commonwealth has a stake in this case, very obviously. The defense certainly has a stake in this case, but the federal authorities have no stake in the case of the Commonwealth versus Karen Reed.
Yeah, he's essentially saying, like, they're not in this to diminish the Commonwealth. They're not in this to help Reed. They're just giving an independent investigation, and that's what they did. And essentially, that's what they did when they hired Arca. I mean, they're just presenting the facts, essentially what Jackson's saying. They're just here to present the facts, and that's what they did when they hired Arca. And Arca came in and said, hey, Karen Reed didn't hit John O'Keefe, and John O'Keefe never made contact with Karen Reed's SUV.
Thus,
Love this
the evidence
argument.
procured by that neutral agency, which is independent of the case, is subject to a
Right.
different and completely different level of scrutiny, a completely different level of assessment by the jurors.
Yep.
That is an important fact.
It is.
There is no other way to truthfully and honestly present this evidence to the jury. Think about some of the questions that the court just posed. What were the circumstances in which you changed your testimony, sir? He's going to say, well, I changed my testimony, potentially, when I was called before a federal grand jury and I was asked questions under penalty of perjury.
Oh, by the way, Kelly just gave me the total. So I just rounded it all up. $133,500 through 5 campaigns for Karen Reed. And Double Good took 50% of that money. So $67,000 they made from that campaign. I'm going to have some words with them tomorrow. I'm going to tell them, look, your company made in 5 campaigns, 5 free Karen Reed campaigns, $67,000. That's what you made. And now you don't want anything to do with us anymore. Okay, that's fine. We'll just take our money elsewhere. I'd rather not give 50% to friggin' any company. I mean, 10% would be great. 5%, I understand it. They're facilitating the product. You got to get paid a little bit. Everybody should get paid for a little bit for their time. I get that. 50% is highway robbery. But at least you can do is let us stick around. Why would you want to? I guess $67,000 is nothing to Double Good. Okay, that's fine. All right. Let's keep playing here.
Why did you finally admit certain things when you were confronted with additional evidence, ma'am? And where did that evidence come from? Well, I was called before a grand jury and I was asked, or I was I was interviewed by a federal agent and I was asked or confronted with additional information, text messages, phone calls, etc. Or the third example, where did that additional evidence come from, officer? Text messages, phone calls, private communications. Oh, it came from a hearing in which I was questioned by a United States attorney under penalty of perjury in front of a grand jury. The jury's entitled to those answers in that context. If we were to do what Mr. Lally suggests, if we were to take that invitation, oh, well, you were asked by a prosecutor at a former hearing, XYZ. That would leave the jurors with the imprimatur of the idea that the Commonwealth elicited those questions, that the Commonwealth did their job, when we know, in fact, it didn't. The answers to those questions directly go to Ms. Reed's Bowdoin defense. Bowdoin talks about the inadequacy of an investigation. Obviously, Mr. Yannetti can talk more about that in just a second. We have information that a different agency was able to uncover information that the state investigation ignored. That's important. And it's important for the jurors to be able to weigh and balance that information and how the information came to light. If the truth is actually hidden from the jury, which is what the Commonwealth is asking the court to do, that the evidence was produced was the product of a third party, the truth being that the evidence was the product of a third party inquiry, unconnected to the state court case, then that jury is left with a false impression, false information, and it'll be unable to properly assess the true facts, which is what we're trying to get to, the true facts. Why is the Commonwealth so intent on hiding the truth from this jury? I'll submit.
Thank you, Kiki. Okay. Appreciate that. Thanks for being here. We like doing these reviews. It's good.
I'll likely rule on that today. So
I love that.
Number 28, Mr. Lally.
All right, let's go back to our double speed here. That was a great argument from Alan Jackson. And if you guys haven't seen it, and ladies and gentlemen, if you haven't seen it, I did some spotlights. I did one on David Yannetti and Alan Jackson. I'd love for you all to go over there and watch those videos. They're right on the homepage if you haven't got a chance. And they were really good. They were really, really good lives. And it was nice. I took everybody through kind of their progressing into their career and into defense attorneys. All right, let's speed up a little bit here. So I want to try to get this under, an hour or 2 hours and 20 minutes or so. It's good. We'll keep it under 10 o'clock, hopefully. All right, let's keep going. This is April
Thank you, Your Honor. So,
12th,
again,
2023, the
similar to
last
the motion previous to it.
trial hearing before.
The Commonwealth is
trial.
not seeking to hide anything from the jury. What the Commonwealth is simply seeking to do is ensure that whatever
Thank you.
information that's provided to the jury is actual admissible and relevant information and not the product of rank speculation. So this motion is seeking to prohibit reference to any pending internal affairs investigation or unfounded allegations of misconduct. And really, primarily what we're talking about here is any sort of internal affairs investigation related to Trooper Proctor and the 20-something-year-old civil case, which resulted in no findings of liability that was referenced by counsel in their motion to dismiss with reference to Sergeant Lank of the Canton Police Department. Under the case law, including McFarland and Graham, the most recent case law, what they essentially attribute is that those types of information, when there is no finding of liability, there is no sustained finding of misconduct, there is no findings of liability by the party at question, that is simply not admissible. And so for those reasons, the Commonwealth submits that this motion should also be allowed.
All right, who's arguing this for the defense? And Ms. Little, what I need to know is what exactly you intend to introduce and how you intend to introduce it.
Thank you, Your Honor. I think it's somewhat premature for the court to rule on this issue. Obviously, the testimony of both of these witnesses is going to be highly relevant as to whether this particular information is relevant. We are still actually receiving information with regard to the internal affairs investigation as recently as yesterday. So I'm happy to kind of defer ruling to the court and then address this as it comes up. I think the court will be in a much better position to rule on this issue once the witness testifies.
All right, so what would be helpful to me, once you know what it is you think you're going to try and introduce, to tell me how that complies with the holdings in both McFarland and Graham.
There are independent reasons why that is admissible outside of McFarland and Graham.
Okay, so I need to know all of that.
Sure.
Okay.
Thank you.
So I'll take this under advisement. And how much time do you need to give me at least a general response now? Can you have it by Tuesday?
We can do that, Your Honor.
Okay. All right, so I'll hold off on that, Mr. Clerk.
Yes, Your Honor.
All right. So number 29, Mr. Lally.
So this motion, Your Honor, is essentially entitled.
Lori, thank you so much for becoming a new YouTube member. We'll add $5 to the total, and you get access to all of the members-only content on my homepage. I just did a great couple of members-only lives this previous week, so you're going to want to get caught up. All right, let's keep playing.
Motion
Almost done.
If defendant intends
20
to
more minutes.
cross-examine any witness about alleged bias and request for a pretrial ruling on whether proposed evidence demonstrates plausible showing of alleged bias. So the Commonwealth is not stating that there are no statements, as the court is well aware, that could be interpreted to reflect bias and could be used by counsel in cross-examination. So what the Commonwealth is not suggesting, and bless you, is for any prohibition on any statements whatsoever. What the Commonwealth is seeking here is a ruling as to what precise statements the defendant seeks to introduce in regard to that, so that the court can make a ruling prior to the witness testifying before the jury as to exactly what's in play and what is going to be admissible and what's going to be allowed, as far as obviously it's not a perfect world, and if a witness were to answer something in a way that would then open the door for further material to come in, that's understandable. But at least a preliminary showing as to exactly what the defendant submits are the statements they wish to introduce in relation to this issue.
Isn't the defendant given broad range and cross-examination as to bias?
Yes, and that's why I indicated early on that I understand that there is some, that there certainly is some areas that
Jennifer.
under the law, whether or not they're true or not, are able to be explored as far as cross-examination is concerned. But what this motion simply seeks to address is there are restrictions to that. It's not
You're right.
unfettered. It's not
That's why I want to
just
do these.
anything and everything that they could possibly think of or say as far as accusations go.
Is there any particular type of testimony you're concerned about? I mean, is there anything in particular that you say they should not be permitted to go into, based on what we've heard throughout the pendency of this case? Is there anything? And I'm reluctant to tie the defendant's hands in any way on cross-examination.
Anna, thank you so
exactly
much.
what it
New
is
YouTube member.
think is
Appreciate
improper.
that.
Okay.
I'm an
And what I
enthusiast.
would do, Your Honor, what I would suggest is similar to the other motions that we spoke of before. I can provide a supplemental with more specifics as to what the Commonwealth's concerns are,
Okay.
if the court would find that helpful.
yes, I can't rule on this as is. So is there any objection to that?
Here's the thing, and I'm just gonna so we can move on. But Char, the bottom line is this: it's money. That's all that matters in all this. I don't care about their terms. I don't care about their conditions. If you want money, and I think we're just, no pun intended, so salty about it now. We just don't even care. We don't want to use double good anymore. But if you wanted to continue to have money flow through your company, take 50% of $133,000, that's $67,000. It doesn't, terms this, campaigns that, whatever. Bottom line is people, companies, they just want money. That's it. So to sit here and pull this whole cores and values and principle shit, I don't want to hear it. Okay. And they made a mistake. They jumped the gun. They should have listened. And a lot of people probably canceled their orders. And I was pretty vocal and professional about the emails that I wrote, and I canceled 3 of mine. So they probably want to hear from me. So, that's the bottom line. But now it's just, if that's the way they're going to operate their company, then we won't work with them anymore. And it's ridiculous. Why would want to continue working with anyone? 50% of everything that comes in. So, that's the bottom line. In my opinion, that's the bottom line. All right, let's keep going.
Mr. Yannetti, you're nodding.
Well, no, I think that makes sense.
Okay.
It was Ms. Little's motion.
Oh, I'm sorry. I saw you
I don't
nodding.
want to step on her toes.
No objection to that, Your Honor.
Okay. All right. So why don't you do that? So, Mr. Clerk, will hold off on ruling on this until we get something from the Commonwealth.
Okay.
So.
Money
Commonwealth
solves
will
everything,
clarify.
believe me. And then when you pull the reality to them, because this is the thing, they take in so many orders. There's no one in customer service or these higher ups that know what's going on. Believe me, they just see a bunch of orders that are canceled probably through this one campaign. But if I bring the reality to the table and say, look, we had, they, Kelly and Paul and all them organized this, brought $133 in. Y'all took $67,000. When you put that reality of that number in front of their face, they're going to go, oh, well, we probably screwed up on this one. Can we do something to help you out? That's usually how it works. When the almighty dollar is in front of their face and they realize it, oh, maybe we can do something to help out. Yeah, why don't you take, instead of 50%, why don't we talk about 10%, 20%, 25%, whatever it is? Work with us. But I think everybody's just so salted about the whole thing, again, no pun intended, that it's probably over. And they screwed up, in my opinion. Screwed up pretty bad.
Right. And then no action taken.
I mean, taking $67,000, they should be sending us a shitload of product that we can just use to sell ourselves.
All right.
Give
So,
100%
as you
of the
know,
profit.
third-party
Aaron
culprit
Reed.
and Bowden are often argued together, often presented together.
Oh, God.
Why don't we just deal
popcorn
with the two
puns.
motions together? So,
That's a good one,
Commonwealth's
Michael.
you're number 30 and 31. Mr.
I'm going to
Allen.
say that on the calls. Quit trying to butter me up, damn it. I'm salty about this.
Mr. Yannetti, are you arguing both? Does it make sense to sort of keep them together?
I agree that they should be kept together.
All right. So why don't I hear you as to your concerns on both? And as you know, sometimes third-party culprit as it goes to Bowden is different than just straight third-party culprit. And actually, it might save us a lot of time. Is that what you intend to do, Mr. Yannetti? Third-party culprit as it
Well-
goes to Bowden, or straight third-party culprit as well?
Definitely third-party culprit as it goes to Bowden, that's for sure. And then depending on how the evidence develops at trial, there may be, an offer to offer third-party culprit evidence with regard to third-party culprits. But I think I can speak further to that in response.
Mr. Go ahead. You can argue these however you want to argue them.
No,
and
look at-
I
she's so
would
kind
argue
to
sort of
him.
in that vein, Your Honor. So
Argue any
understanding
way you
that
want, Mr. Lally.
based on the state of the evidence, as I anticipate it to be, and in any case, regardless, I think a defendant in any criminal case has a much better shot, essentially, at getting evidence in regarding to Bowden as sort of a backdoor through, as to third-party culprit as sort of a backdoor through a Bowden defense. So what I'm primarily concerned with, Your Honor, is motion to eliminate number 30, because as the court is well aware, there have been a number of theories of sort of speculation, rank speculation, opinions without any evidentiary support, names of certain people that have been dropped at this microphone by counsel at different pretrial hearings who are not witnesses, who have nothing to do with this case, who don't know anything about this case, who counsel, when they said those names and sort of dropped those, whatever they supported to be facts, knew that they had nothing to say and nothing to do with this case. What I'm concerned about is whatever is acceptable as far as believability when it comes to arguing things in pretrial motions, shouting things from courthouse steps, or bandying about on Twitter is not what we do here. And so now it is a time where counsel is going to be relegated to what is actual, admissible, relevant evidence. And what I'm asking for in this motion is for the defendant, through her counsel, to actually provide any admissible or relevant evidence that pertains to third-party culprit, which to this point they have not done. So if this is something that's going to be raised as an issue on its own, as the court is well aware, what the case law indicates is that the acts of the other person are so closely connected in point of time and method of operation as to cast doubt upon the identification of the defendant as a person who committed the crime. It has to be specific. It has to be to at least a specific realm of person or a specifically identified person who would have motive, opportunity to commit the act with which the defendant is charged. And up until this point, I have not seen anything specific as to that. As it pertains to the Bowden motion of the Commonwealth file, what the Commonwealth is asking for there is notice and voir dire in relation to a Bowden defense. So if there is, again, going to be some, I don't think the evidence comes anywhere close to a Bowden instruction, but certainly what the courts have said over time is that a Bowden defense is something that if the evidence warrants it, counsel can elicit testimony in regard to it or attempt to and make arguments in reference to it. So I'm not seeking to preclude counsel from making arguments or from counsel asking questions. What I'm seeking clarification on is what exactly, and again, this is from a position of operating without any information whatsoever as to what a defense may be. And understanding that counsel was not required to provide any information until the Commonwealth filed its certificate of compliance. But there's been, regardless of whether they were required to or not, I'm going into trial on Tuesday without any information whatsoever as to who they've spoken to, what what statements they might be, who their witnesses are, or anything of that nature. So for those reasons, the Commonwealth feels it appropriate to at least file a motion to be given notice as to exactly what the defendant intends to do. This trial by ambush is simply not something that's permitted by the case law, and that's what the Commonwealth is seeking to prohibit in that second motion. Thank you.
Okay. All right, Mr. Yannetti, I'll hear you.
Thank you.
And though they're argued together, I do want you to also start with the third-party culprit alone, not third-party culprit as it goes to Bowden, but third-party culprit alone, because of all those factors that I told you, as you well know, the case law is clear, that I have to consider. And if I had to do it now, and you know I can do it pre-trial,
It's the loud
right? You know that I can, today I can just exclude it. I'm not inclined to do that, but I need to be able to make those decisions, to weigh those factors, because right now I have zero information on
Right,
those.
I understand that, Your Honor, and that was my plan going into today anyway. So the initial question is, why is there a third-party culprit defense? Why is it relevant? And we start, Your Honor, with the fact that our forensic medical examiner, Frank Sheridan, a forensic pathologist who has performed himself thousands and thousands of autopsies, has already submitted a sworn affidavit to this court that John O'Keefe's injuries are consistent with having been in a fight and are not consistent with having been hit by a car. Since he submitted that affidavit, the federal authorities have provided us with their reports, whereby FBI experts also corroborate that John O'Keefe's injuries are not consistent with having been hit by a car. They employed experts in biomechanics and kinematics who have reviewed the evidence in this case, and they've confirmed that the physical evidence essentially shows and doesn't show what Dr. Sheridan has opined. So therefore, if John O'Keefe was not hit by a car, that means that Karen Reed did not kill him. And we know that John O'Keefe did not die of natural causes. This was not a heart attack or a stroke. John O'Keefe was injured. He was mortally injured. If he was not hit by a car, as both our expert and FBI confirmed, then he was attacked. And if he was not hit by a car, then there is a third-party culprit or culprits. So by asking this court to prohibit the defense from introducing evidence that others had the motive, opportunity, and the means to attack John O'Keefe, the Commonwealth is essentially asking this court to prohibit Karen Reed from being able to defend herself.
So I don't think they're asking that you be prohibited from doing that. They're asking first to have you tell them what that is.
Right. Well, this is, Your Honor, I'm getting to that in terms of
Go ahead.
Let
You
him
have
talk.
your
that
remarks.
we're either required to give them or not.
Jesus.
It is not our job to solve this case for the prosecution. It's our contention. They had the opportunity to do that, but they failed. It is not our job to name a specific third-party culprit. We do not have to prove that Brian Albert or Colin Albert or Brian Higgins or some combination of them intended to kill John O'Keefe. We don't have to prove that any of them attacked John O'Keefe such that he eventually died. They have to prove beyond a reasonable doubt that they didn't. But the fact of the matter is there is evidence that all three of them had a motive, had the opportunity and the means to attack John O'Keefe. Now, the Commonwealth cites Commonwealth versus Conkey in their motion, and as this court started the discussion on this issue when you first took the bench, Conkey makes clear that a defendant has a constitutional right to argue that somebody else may have committed the crime. And certainly, no, the acts of that person can't be too attenuated in time or method of operation, as Mr. Lally mentions. But in terms of being the right time period, Your Honor, you can't get any closer than their presence at the scene at the very time that John O'Keefe was killed. And in terms of the method of operation, given that we have evidence that he was not hit by a car and that he was attacked, all three of these men, either alone or in combination, possess the ability to attack him with or without a weapon. I mean, it's a very low standard here. The Commonwealth acknowledges that. It's a low standard of simple relevance. And the evidence here establishes relevance. Now, I would note, Your Honor, the Commonwealth cites Commonwealth versus Finney. I don't know if they realize this, but that was my case. I represented Roland Douglas Finney before the Supreme Judicial Court, and I represented him at his motion for new trial and at his retrial. And that case, the Finney case, provides strong support for the introduction of third-party culprit evidence here.
It's so funny he's
irrespective
part
of
of
a
that.
Bowden defense. In fact, the reason that Mr. Finney's conviction was overturned was that his trial counsel failed to pursue a third-party culprit defense. And Your Honor, the third-party culprit defense in Finney was weaker, far weaker than the third-party culprit defense we have here. The evidence of motive in that case was that the third-party culprit made derogatory statements about the victim after she was murdered. No witness in that case put the two of them together. No witness in that case put the third-party culprit at the scene of the murder where the victim was murdered. There was some consciousness of guilt evidence similar to what we have in this case.
Hey, Cam.
But in Finney, the SJC ruled that not only was that enough for a defense attorney to present a third-party culprit defense, but he was ineffective for not doing so. And as the court has also touched upon, the SJC found that on the basis of that third-party culprit evidence, which is weaker than what we have here, there were substantial connecting links between that third-party culprit that justified the admission of hearsay in that case. And I want to make it clear, we're not looking to introduce any hearsay statements, so we don't need substantial connecting links here. Now, Your Honor, I could go through with the court the specific evidence we have with regard to motive, opportunity, and means with regard to the three Commonwealth witnesses that I've named.
So go ahead.
Happy to do it. Starting with Brian Higgins.
I remember this now.
He was present at 34 Fairview Road on January 28th to 29th. He was close friends with the homeowner, Brian Albert. He had prior romantic interest.
See, the thing that sucks here is that because of all the connections, this was never properly investigated. So Karen's defense team has always had their back up against the wall and having to explain over and over again, Brian Higgins, Brian Albert, Colin Albert, and has to keep explaining where they were, what they did, what was the possibility, what is the evidence. And on fact that this wasn't investigated properly, there was also a cover-up on top of everything. And, it's always like they're swimming in water with their back up against the wall, if that makes any sense. I don't know why I just made that analogy. It probably doesn't make any sense, but I think you know where I'm getting at. And that it's just this constant fight and battle and fight and battle, because the real facts were never put out there. The real evidence was never put out there. A fabricated version of events were put out there, and that was what was brought forth. So it's constantly fighting. I mean, it's got to be mentally draining if you're any of these attorneys. If you're in Yannetti Jackson or Little, it's got to be mentally draining. The end of the night, I'm sure probably at least one night they all just went home and they were like, "Fuck," because it must just like how can this all be this stupid? It's very clear what happened.
expressed in Karen Reed. He did not expect Karen and John O'Keefe to be at the Waterfall, that bar, on January 28th. Karen Reed did not greet Higgins, despite the fact that they had previously exchanged flirtatious texts and that she had been at his apartment one evening, although there was nothing that took place between them any more than a peck of a kiss.
Chloe cover up.
At the Waterfall, Higgins does not engage with John O'Keefe. He does not say goodbye to John O'Keefe and Karen when he leaves. But before he leaves, he texts Karen, and that text was something to the effect of, well, with a lot of M's. We know that there was a preservation order from this court, your predecessor, Judge Krupp, to preserve his cell phone, and that Trooper Proctor gave him an edict, an order to serve on Brian Higgins, and he left it at the front desk of the Canton Police Station for him. And that Higgins, we learned through the federal investigation, Higgins became angry, demanded that Proctor come back, and he essentially upbraided him and read him the riot act, which shows a little bit about Higgins' personality. At the end of the night, everyone discussed going back to 34 Fairview, and when he gets back to 34 Fairview, he texts not Karen, he texts John O'Keefe at 12:20 a.m. He testified before the federal grand jury that he had no knowledge that they had been invited to 34 Fairview, but that is contradicted by this text message. And the inference is that he was coaxing John to come to that house. And, we're not saying this gives him a motive to kill John, but we don't have to show that. Any motive to feel hostility or animosity towards John O'Keefe goes to his motive. And Your Honor, when Brian Higgins and Brian Albert are in that house, they're the only two people who are unaccounted for when the rest of the group was in the kitchen. And they claimed that they were looking at photographs together. And we have evidence that they were in the basement. We believe that Brian Albert made a mistake before the state grand jury by testifying they went upstairs to look at photos. Brian Higgins says unequivocally that the only place the two went was into the living room to look at photos and military ribbons, whatever they were looking at. Brian Higgins did not know that Brian Albert had said they went upstairs. And he also testified he had never been upstairs at Brian Albert's house in his life. That means that if Brian Albert said they went upstairs, they're coming up from the basement. And before leaving 34 Fairview, Brian Higgins testified he was parked right in front of the mailbox. He would have had to have walked by where John O'Keefe's body was. His headlights, when he got in his vehicle, would have been illuminating where John O'Keefe's body would have been in the yard if it were actually there. So how does he not see it? He then goes back to the Canton Police Station at 1:30 in the morning after leaving 34 Fairview. He claimed to do some administrative work, but then he admitted to the federal grand jury that he was there to move his car because of the upcoming snowstorm. This suggests that he was fabricating a reason for going back to Canton Police to establish an alibi for himself. He was asked several times at the federal grand jury if he had any conversations with anyone before he went to bed. And when was he notified that John O'Keefe was dead? In the morning, he said. He testified under the pains and penalties of perjury that he had absolutely no contact with any person that night for any reason whatsoever. But he apparently was surprised that the federal authorities had subpoenaed his phone records, and he had to admit, and he did admit under oath, he made that 2:22 a.m. phone call around the same, about 5 minutes before Jennifer McCabe is Googling how long to die in the cold, about 8 minutes before Brian Loughran, the plow driver, first drives by the house and sees nobody at all. And the next morning, Brian Higgins, the first person he spoke to was Brian Albert.
I'm going to stop you for a minute. I think we need a break, Madam Court Reporter. Do you need a break? Can you go? How much longer do you think you have with this, Mr. Yannetti? How many more pages or how long you think?
I've got about, in terms of my recitation of the facts, I've done about a page and a half and I've got 3 left.
Madam Court Reporter, would you like to take a little break? It's hot in here and you've been going nonstop. Okay, let's take a 10-minute break.
He's pissed. I don't think we're going to come back. I think this might be it.
He does not say goodbye to the 29th of that third-party culprit defense we have here is Finney. I don't know if they realize this, but that was my case. I represented Roland Douglas up from the basement.
How many?
Yeah, I don't think they come back. That might be it. Yeah. I think we get the general overall point here. I think there was a part 2 to it, but I didn't. Yeah, the break is like, oh, we got to take a break. Bev, we got to take a break. She needed a beverage. But I think we get the point. But again, I just want to go over these just to get some review. Tomorrow, again, I don't know what's going to happen tomorrow. I assume the hearing is going to be, in my estimation, 10 to 20 minutes long. So we'll have to see what happens tomorrow. 2 p.m., Dedham Superior. I will be out there in support of Karen, of course. We'll see what happens. It's 2 p.m. tomorrow. I'm not sure if it's going to be televised. I'm pretty sure it's going to be because of how hot this case is now. And knowing that there is going to be multiple documentaries about this, they're going to want everybody to start seeing this. Nettie's tweeting right now. Or he was tweeting about it tonight. Let me see. I don't see him tweeting about it or anything. But I don't know. That's it, folks. We have a total, Rogue. What do we got? We'll get a total. I'll make the donation tonight. I'll drop it on the Facebook page, on my community page. You know how I'll do it for the transparency. And then you can go right to the events link and see the transparency. Let's wait to see what the total is. And then I'm going to get out of here in about a half an hour out of the studio. I've been kind of changing things around a little bit because I didn't like the articulated arms on the mic stands. I like this one. I'm not touching it as much. So I think that's working out better. So we're at 286. 25% will go to Karen. So 71, I'll round it to 75. We'll make a $75 donation tonight. Thank you all so much for your donations. Welcome to all the new members. Thank you for continuing to support my channel. Tomorrow at 8 a.m., I have a body cam video that will be dropping on my channel of a case that I had been following here for quite a while, and that is the Anthony Farah timepiece gentleman. He's currently in custody in Los Angeles under federal investigation, and he's facing charges of wire fraud that could put him in prison for 20 years. His trial will be coming up in October. There is rumors now that there is a production company that is trying to work with him to put together a documentary for Netflix and sell his story. He absolutely needs the money. He was a YouTuber that defrauded $5 million from his clients. He used to be a wristwatch YouTuber and would deal in very high-end watches. So I attained a body cam footage of when he went down to Arizona in May of last year and claimed that a watch had been stolen and sold to this specific jewelry store, and he went to claim it. It's a $250,000 watch. So he essentially was trying to steal it back. It was part of a scam. So that will drop tomorrow if you have any interest in that. I'd love for you all to come over and check it out. And hopefully the algorithm does good things with it and pushes it out there. But I think that's going to be it. So thank everybody that came out to the Taunton Standout today. If you were out there, you did a phenomenal job. I would love to organize one again. It's a perfect place. You're out of the safety of, getting in any accidents with traffic. There's plenty of space. There was shade. It was just a great standout. And then going to the Star Drive-In after, drive-in was awesome. The food was great. We had a great time. I got to sit out with Kelly and Paul Cristoforo and a bunch of other people. We met a lot of Free Karen Reed supporters. It was just a great time. It was a nice afternoon. It was nice to get out of the house and do something like that, and then come back and do this live. So that's going to be it, everybody. I'm going to hit the outro here. I appreciate you. I'll make the donation right when I get off air. If anybody needs to get in contact with me or you want to shoot me an email, let me know how the show is going, or if you have anything else you want to say, I'll drop the email there in the chat. Email me. Let me know your thoughts. I appreciate it. And let's see some pink hearts on the way out. Flood it. pink hearts for Karen Reed. And tomorrow I'll be out there in the morning doing a live for about not tomorrow morning. I keep thinking tomorrow morning. Tomorrow afternoon, I'll be out there doing a live at about 1 o'clock. Hopefully we get good signal. There's going to probably be a lot of satellite trucks around there. If not, you know what I do. I'll get some good video and post it up later. So thank you, everybody. Flood the chat. I'll talk to you all soon. And always remember, like Alan Jackson says,
it makes absolutely no sense. That is the Commonwealth grasping at straws. If it walks like a duck and talks like a duck, it's a duck. Take the change and set the trap, run over many a time to walk down. They try to control us with their lies and their schemes, but I'm a rise above, fulfill my wildest dreams. The beat be bang, the rhymes be tight, trap rap flowing through the darkest night.
Wait a minute. Whoa. I got to go back here. Wait. Miss Jessica. Oh my God, Brian. I know Anthony. I met him in 2016. You need to email me pronto, and I want to speak with you. So please email me. Tell me about the experience. Where did you meet him? I'll drop my email here. It's let's talk live podcast at gmail.com. You need to email me. I need your story. If there's any significant substance to it, you need to talk to me about it. I want to hear the story because that will make for a great video here for on the channel. So please reach out to me. Let's talk live podcast at gmail.com. I would love to hear from you, Jessica. Please. Anthony Farah, Timepiece Gentleman. I want to know all about it. Email me on it. Perfect. We're going to get together. We're going to have a conversation. I need the scoop on Anthony Farah. We need some new content out there. And by the way, if anybody is interested in learning about the Timepiece Gentleman, it's a story I've been covering for a while. There just hasn't been a lot of new information. You need to go check out my #1 video on my channel. Has 152,000 views on it. It's when we confronted Anthony Farah. And I'm going to drop the link for that if you all want to check it out. It's only a 36-minute video, but it's hell of a worth watching. Go check it out. Leave a comment. Get interested in this story. I'm telling you, it's a huge fraud scandal story. Once you get turned on to it, you will not be turned off. And I'm going to have more on this case soon. So, all right, I'm going to hit the end for sure now. But I want to hear your story, Jessica. Email me. All right, everybody, I'm out. Good night.